Mother was arrested, minus on his heart patient.
Make a mention before court number 16.
Hello?
Court number 16.
Your lordship is senior, that's why I'm making.
No, I'm not taking the regular bail bench. That's
Obliged.
May please your lordship. Alright, this I pray for listing of a matter. This matter was listed yesterday.
no. What kind of matter?
AB, it was one time rejected by your lordship, my lord. It was
Make a mention before court number 16. Matter will come before.
your lordship, yes.
No. Court matter will come before this court only.
Because your
Make a mention only.
problem is that, my lord, yesterday this matter was come up, my lord. And when it was called, I was in another court and your lordship had fixed it in 14/10.
That's
But
what
similar
Make
matter,
a mention before court number 16. It may be, you make a mention that it may be 14/10, not before the vacation. That's mentioned.
hello.
Please, Your Lordship, I beg to mention item number 9 on behalf of C. Bora, sir. He is, because of flood, he could not come today.
That is already there, na? For whom you are appealing?
C. Bora, sir. C. Bora, sir.
C.
Respondent 1, yes.
Other side is just R.D. Mujumdar was there.
Oh.
Have you informed them?
No, just now only I got, he's stuck on the one, he's, because of flood. I
No,
could not-
because of flood, that's what.
Yes, yes, yes.
R.D. Mujumdar is there.
Oh,
You have just
take-
now. It was an hearing column, na?
Yes, yes, Lordship.
Both 9 and 10, I think.
Yes, yes.
Just you inform the other side.
Okay, Lordship.
You are MS?
Tinlung.
Yes,
TINLUNG.
appearing on behalf of Mr. C. Purva for the respondent. Just submitted that the NTS council not happy with what court due to sudden situation. However, she stated that she will inform the other side about considering the submission made by MS so and so. Matter is adjourned. List accordingly. It is of 2015 matter.
Yes.
So after vacation, you immediately after vacation,
Immediately.
it will list it immediately. There are one I is also there. Do you know about the I?
No,
What is
Lordship, I have no instruction regarding the new instruction.
because this I is filed by you only, not by the company.
Okay.
So that's what I'm asking. Okay.
All
List
right.
after vacation. Immediately after.
All right.
Right to the lordship. My lord, in item number 20, my lord.
20.
Yes, my lord.
Huh.
My lord, last evening, my lord, I had mentioned before this honorable court. Honorable court had allowed my prayer of bringing that IA, my lord. I had filed an IA for withdrawal in this case, my lord. Unfortunately, that IA has not come up, my lord.
You have already filed?
Yes, my IA is already
We'll make an inquiry. If it is already there, we'll call for.
my lord.
If it is there, then we'll call.
My lord.
I had a file close. Just a second. Oh, acha. IO is saying that just me corrected me that IO has come by listing only. So in that case, if you have filed the IA, then maybe listed by tomorrow or by day after tomorrow.
My lord, then in item number 20, my lord, I have a similar prayer because this matter has just been listed. My lord, like my learned friend was making a prayer, my lord, I have to see the LCR in this case, just that. I could not get hold of Miss R.D. Mujumdar. I will try to reach her otherwise. I will require some kind of accommodation on item number 20, my lord, for today only.
No. IA in which item you have filed?
I have filed an
20
IA,
only?
yes, my lord. But if the IA comes separately, my lord, then this item, my lord, may not be taken up today. That is my request.
Then we'll pass an order.
My lord, then I have
IA
to intimate Miss R.D. Mujumdar, my lord.
You have to intimate her.
I'll get
In
hold
that
of.
case, it may be listed, but day after tomorrow.
My lord, I'll
will
get
come.
hold of her, then my lord, my pass.
Okay, then I'll just for time. Okay.
Deep look.
Bamba. Pick up along with the item file. And I will
May I please, Lordship? Lordship, this is second application, Lordship. Today, I'm not going on the merit of the case, Lordship. As on today, 79 days behind the bar, Lordship. And in this long custodial detention, accused are never interrogated by the investigation agency, Lordship. So further custodial detention, when is
So
the
what
required?
kind of case? What nature of?
Kidnapping, abducting, wrongful restraint, and dacoity, Lordship.
It's a case of equity. Where is the earlier rejection order?
Pardon?
Okay, yes, earlier rejection order was there, na?
Yes, Lordship.
21/8/2025.
Yes, Lord. Page number
So within
28,
a very short period you have come.
79 days, Lord.
No, that was rejected only on 21/8.
Yes,
They have come very short period, yeah.
that was 53 days at that time, Lord.
It is a charge sheeted case,
Not yet charge sheet, as
Huh?
per
not
instruction.
a charge.
No, Lord. As per instruction.
Yes, that's, there was, order was there, the rejection order.
Yes.
So he is submitting that is 79 days in custody.
Yeah.
Uh,
So Lordship, it was rejected on merit law.
hmm.
That is, and he have to show the new ground. Lordship.
There's no ground, only long interest.
Tension, yeah.
But I'm just wondering whether it is a case is already charged or no.
No, we have no information on that.
You are appearing now, this petition is filed for both two accused, is Shahjahan and Hafizur, or
For both.
for both?
For both,
For-
Lord.
Yes, what to say? Or at best we can call for,
Lordship, that one.
or you can take instructions regarding the filing of the
Lordship,
traffic.
I'll fix it on another day. I
Because it
will,
is already disposed of,
Lordship, I
considering the
will
merit.
take instruction on.
Pardon?
I will take instruction whether the charge sheet has been submitted or not.
Then by the time whether you want to call for the case diary also. Oh, Mr. Thakur was earlier, you were earlier. Then on what date? Maybe on 23rd. Schedule for review. 23rd of the learning additional review will take instructions as to the stage of the investigation and as to whether any charge sheet has been filed. Listed. Okay, well, listening.
Please, please.
23rd.
The second time, my lord. This, I think your lordship dealt. Detailed order has been passed, suicide matter, my lord. 3 matters were moved, I am for the architect. I am for the
Oh,
architect. Now
you are
today
for
is
the-
54 days. After a gap of 28 days, we have moved the matter. So it is 90 days, but by the time case diary is called for, by next week it will be 60 days up.
No, at present, how many days you are?
54 days.
54.
52, no?
54.
54 days.
90 days of.
90 days.
Oh,
only.
it's a case of 90 days.
54 days now. He has received message, whatever, rightly, wrongly, the message he has received.
Yes,
So it can be only next week, my lord. Case diary has to be called for.
yes, when it can be.
On 26.
26 may be the last day, no? When it's
26,
about
no?
11.
Not 26.
Tuesday and on Monday, कोई ले बता। 25th is Monday. 22nd is Monday.
25th is Thursday.
23rd, 23, by the time 61, 62 days it will be. 23 or 24, whichever is
24
con-
can be
24.
city performance. Assisted by P. Sen. Assisted by Mr. P. Sen. Okay, we're calling it on, we're fixing it on 24 plan.
24. Clear.
Item number 3. There, nothing. নহলে আকৌ পিছুৱাই যাব item number 3. Non-appearance on call for the petition. Hard Mr. KK Dutt, Jilla Litigation PP, appearing on. Please the matter accordingly after vacation as an editor provided.
Lordship non-appear.
Non-appear. One more really case has.
Lordship, another item is also there.
Yes.
Bail hearing, 5. But,
Item number 5 is bail hearing.
but the CD is not available now.
But if like anything must. Oh. Customer.
Item number 5.
May I please, your lordship? This is second bail application, lordship. 60 days mandatory, your lordship. As I'm behind our
60 days. So you are in custody since when?
53 days. Second bail application, lordship.
Rejected.
Rejected on 27/8/2025. Lordship, kindly consider also.
When it
53 days, lordship.
Lordship on
make it on 22nd or 23rd. Would better fix for us.
22nd.
22nd?
Lordship, it will be better 23rd because we have also take information. We need to take information on 23rd. On that day, 23rd.
It is not the case of other case.
On another case, Lordship, the CD is fixed for 23rd. I want to state
For
that
out of same FIR.
no same affair, Lordship. That will be better because otherwise only one case will be fixed in on
So
23rd.
what, fix it on 23rd?
23rd.
Listen, CD is not business issue, remind. Oh,
Lordship.
yes. তারপর কই দিব থেকে ও কাবি না কাটবো and কেন কই দিব আমাকে ভিডিও লিংক দিয়ে দিব I'll say it. So, company will leave. I think we'll leave it. 944. Company is- Non-appearance call for the petitioner. Itu pakai service charges pakai usil. Whoever non-appearance call for petitioner, needs the matter recording after his application as an indicated fixed by the ministry. Orders. দুটো বিষয় দেখুন
All orders, number 6.
May I please, Your Lordship. In this case, my lord, last occasion, LCR was called for, but that has not been received. And secondly, one order was passed to reflect my name in the cause list. That was also not done, my lord.
Your name is not there, no?
Yeah, yes, my lord.
And you are for the respondent, how many respondents? How many?
Sole respondent, my lord.
Sole respondent.
So we are
You've already
already.
appealed.
But a date may be fixed after puja, so that the LCR may also come.
Appeal is already admitted.
Already admitted, earlier occasion it was dismissed for default. And on that account, LCR was sent back. Later on, it was, my lord, restored.
No, but whatever, it has already been admitted.
My lord, admit.
Heard Mr. You are Mr.
Lord A. Bhatra.
A. Bhatra. Heard Mr. S. Sahu, the learned counsel for the appellant. Also heard Mr. A. Bhatra, the learned counsel appearing for the respondent. On the office note, it appears that the as TCR has not been not yet received. Issue reminder, residual duty needful. Further, it is submitted by Mr. Sahu that in spite of the order dated 12/8/2025, passed by this court, comma, the name of his name is not reflected in the call list. In view of this, the registry is thereby directed to reflect the name of Mr. S. Sahu in call list, the next date of list. It is the matter immediately after receiving the LCL, residual duty needful list.
Yeah, may I pray for a date?
Yeah.
After puja.
Puja, any date you have?
Huh?
16th of October.
Still, after
Well, you make it 30th because I
Yes,
don't think so LCR will come during the puja. 38 is a 12.
30.
30. 30.
obliged.
Number 7.
Lordship, I need some more time to file objection in the additional affidavit. I am for the transport department, my lord.
Transport Department.
No. They have filed an additional affidavit.
They have also filed one IA. IA is for what?
They bring on record some notification of the government regarding enhancement of the vehicular price. That IA, lordship, notice has been issued on last occasion, so need some time to file objection, my lord.
Or in connection with that IA,
Lordship.
none appears to fall for the appellant, applicant. Heard MS
MD Bora
MD Bora.
for transport department.
Understanding council, transport department, and accordingly. It is submitted that she need some more time to file their written objection. They are allowed, this is the matter according after puja will do,
After vacation.
after vacation as on a date to be fixed. And appealing the respondent file their written
Yeah, I-
objection. Okay.
I'm so deeply obliged, lordship.
And for the appellant. Your lordship may kind password for the time because they are on the way, my lord. They have informed me.
Okay.
Much.
Standing.
Lord, want my lord some accommodation, my lord. Due to heavy rain, my lord. My senior is on the way, man. We will appear, my lord. Just a few minutes. Obliged.
May please, your lordship.
Mr. Second, you are for the appellant, na?
Yes, lordship.
Senior counsel, Mr. Mohanta is also there
Yes,
for the respondent. Most probably
Math is junior.
you met him.
Math in, they are coming. They are coming. They have come. When to bring the filers? They are.
No,
His junior will be
they are
happy.
coming, but I don't know they are whether they are going to or good in
No, they will agree. They will agree.
They will. Are.
They will
Okay,
agree.
for timing.
I may start. He will be reaching. He just went for the testing.
एक बार कोई दूसरे नहीं की है अगली कॉल
He just went. He just went to bring the file. In the meanwhile, I can read the judgment, lordship. If lordship permit.
So what I'm saying that I don't want to keep anything part heard. If I'm going to hear, I'll hear the matter. So that's why I mean they are coming.
They are coming and they are ready to do. Yes. Just now he has told that he is also ready to do it.
Huh?
Mr. Abhilash Bhasasaji will be doing on behalf of Mr. Lordship, Mr. A. Bhasasaji will be doing the argument from for the behalf.
A. Bhattacharya.
I met him. Right? Lordship, yes. Captain.
You are going to argue,
Yes.
no matter. Both 12 and 13 are connected.
Yes, analogous case, Lordship.
And
Lordship may take the 13 first. It is the item number 13, Lordship. Item number 13 is an injury case. The claimant himself is an eyewitness, Lordship. Item number 12 is a death case. So I'm taking item number 30 because he is the eyewitness also in that, Lordship. And my ground of appealing the both the case is the same, Lordship. Lordship, my ground is
so you are for the company.
insurance company, Lordship. My ground of appeal is there should be contributory negligence, and my DL of our vehicle was not valid at the time of the. That was the main ground.
One is the contributory negligence.
Contributory negligence. In the both the case. Lordship, may I read the judgment? Lordship. The claim petition has been filed by the claimant Muninder Mohan Kolita under section 167 40 of MVF for injuries sustained by him in a vehicle accident occurred on 17/10/2013. The fact of the case in brief are that on the date of the accident, 17/10/13, when the claimant was proceeding as an occupant from Nonggaon side towards Guwahati side on the left side of the road in a spark car, when he reached nearly overbridge on National Highway, all of a sudden a truck bearing so-and-so coming from the opposite direction. They have admitted it is in the opposite direction. In a very high speed, came on the wrong track and knocked the opposite car from the front side. Consequently, which he sustained grievous injury on his person. The claimant is of the view that accident took place due to rash and negligent driving of the truck. OP number 2 and 3. The owner and the driver, respectively, of the offending vehicle did not contest the case and case proceeded ex parte against them. Owner and driver did not appear in the case. We have lots of one thing is important, the accident occurred at nearly overbridge. Lordship may be aware from Jagaria to Nonggaon, it's a straight road. There's no curve. So you can look very far. You can, when you are going, you can look to what vehicles are coming from the other side. OP number 1, the New India Insurance insured the offending vehicle. In his written statement, disputed the factual aspect of the case as narrated in the claim petition and wanted strict proof. The insurer also declined to accept a liability if there was any violation of term and conditions of insurance policy, and if the driver did not have a valid and effective driver license to drive the vehicle. The insurer filed this is important also. Insurer has filed additional written statement. We have filed an additional written statement contended that a driving license so-and-so issued by DTO Urukul Manipur in favor of the driver Kiran Seika of the vehicle number so was verified in the office of DTO Urukul Manipur, and it was found that the said license was found to be incorrect and forgery. So the driving license was a fixed driving license. Yes. Upon the pleading, the following issues were framed. May I read the issues? Whether the claimant Muninder Mohan Kolita suffered injury in the LS road accident dated so-and-so involving vehicle so-and-so, and whether the said accident took place due to the rash and negligent driving of the driver of the offending vehicle.
whether the claimant is entitled to get any compensation, and if is, to what extent and by whom among the opposite party that says compensation will be paid. Claimant has examined himself at PWN1 and proved some documents. The contesting opposite party insurer has examined 2 witnesses on his behalf. We have examined 2 witnesses. I have heard the argument for the parties and carefully pursued the entire matter brought on record, and my finding on the above issue are as follows. Issue number 1. Both the issues are taken up together for decision and discussion for sake of convenience and brevity. Both the issues were taken up together. Evidence of the claimant is that on the day of the accident, 17-10-13, when he was proceeding as an occupant in his parked car from Nagaon side towards Guwahati side, on the left side of the road, when he reached nearly overbridge on National Highway, all of a sudden a truck bearing so-and-so, which was coming from the opposite direction in a very high speed, came on the wrong track and knocked the opposite car from the front side. From the front side, they have admitted it is a head-on collision, causing grievous injury on his person. According to him, the accident occurred due to rash and negligent driving by the driver of the offending truck. After the accident, he was immediately taken to GMCS while he was admitted into treatment there, and he was admitted to GMCS on 17-10-13 and discharged on 23-10-13. Nothing has been elicited during the cross-examination of PW to raise any doubt regarding the veracity of the above claim on the issue. Contesting opposite party also has not adduced any contradictory evidence on the issue. He has proved Exhibit 1, 1 to 3, search sheet, injury report, support his claim that the opposite accident involved the opposite offending vehicle so-and-so took place at opposite place of occurrence in the opposite time of at the opposite date, and the Jagiroad PS case number so-and-so regarding the accident against the driver of the truck. In the view of the evidence on record, it is found and held that the opposite offending vehicle truck was solely responsible for the accident. Accident took place due to the negligence of the vehicle number so-and-so, which was inserted OP number 1. Issue number 1 is decided in favor of the claimant. In view of the decision in issue number 1, it is found and held that the claimant is certainly entitled to receive compensation in this case. In determining the quantum of compensation claimant is entitled to receive, let us first find out the nature and extent of injury suffered by him in the accident. The nature and extent of treatment received by him such accident, extent of accident incurred by him for such treatment. Regarding the nature and extent of injury sustained by the claimant in the accident and the nature of the extent of treatment received by him for such injury, according to claimant PW1, he sustained fracture staff of right femur upper 1/3 in the accident. After the accident, he was immediately taken to GMCS and he was admitted here on so-and-so and discharged on so-and-so. He was diagnosed as sustained for fracture injury in his right hand, and his right side hip joint was dislocated and also started spinal injury. We are not disputing the injuries at all. Claimant has proved Exhibit 3 as a discharge certificate issued by GMCS and medical prescription report bill amounting rupees so-and-so. We are not disputing that amount. Exhibit 3 is the discharge certificate issued by GMC showing that he was admitted there on this and discharged on this. He was diagnosed as sustaining from fracture distal and dislocation injury, including fracture injury in the accident. Exhibit 4 is I'm skipping that part because we are not disputing the injury. Lordship may come to the last paragraph regarding income. According to the claimant, at the time of accident, he was owner of a grocery shop at Sanmari, and his monthly income was 10,000. But the accident, after the accident, his shop was closed for about 9 months. But he has not filed any documentary evidence regarding his permanent disability. However, he could not produce any documentary evidence regarding his profession and income. No income proof and occupancy proof as well. It was only stated that he has a grocery shop at Sanmari. As per discharge certificate, so that he was admitted in GMC, showing he was admitted from so-and-so. He took treatment for 40 days. But the nature of injury sustained by him, it is found that he must have keeping out of work for at least 6 months. As such, an amount of rupees 30,000 is awarded for loss of income, and his income is assessed as 5,000 per month. No such income of 5,000 was taken. Consider nature and extent of injury. In the accident, it is held that he is also entitled to receive an amount of pain and suffering, loss of immunity, accidental expense towards hospitalization, transportation, special food, nothing. Thus, the total compensation is for entitled to receive as medical expense, pain and suffering. All the expenses were given under the different headings. We are not disputing that. Now, our DW. The insurer examined 2 witnesses to prove the driver of the vehicle did not have a valid license at the time of the accident. Sri Ashish Bhattacharjee, insurance investigator of the New India Insurance Company, is examined as DW1. He has stated that he has deputed to investigate the state along with the driving license of the vehicle so-and-so. After investigation, he has submitted a report stating the driving license number so-and-so was not valid and effective driving license, and it is a fake license. Exhibit A is the verification reply issued by DTO Urukul, Manipur. During cross-examination, he admitted he visited the house of the owner, but the owner did not give statement. Ms. Sriti Burma, Administrative Officer of New India Insurance, is examined as DW2. She has corroborated the evidence of DW1. Exhibit B is the certified copy of the insurance policy containing 2 pages of the vehicle number so and so. In cross-examination, she has admitted the policy of the vehicle was valid at the time of the accident. She has also admitted as per policy condition the victim is a third party. She has also admitted that her evidence is based on the report of the investigator, but no official witness of DTO Urukul, Manipur has come to prove the aforesaid document. In given circumstances, it cannot be held that the driver of the vehicle was driving the same without valid and effective driving license, and insurer has failed to prove that on the date of accident, the driver was not having a valid license. Hence, the insurance company is liable to pay the compensation. Lordship, we are challenging this part, the later part. Lordship, here, my first was contributory negligence. Here, the claimant has admitted that it was a head-on collision. It was a straight law. And Lordship may be aware that in head-on collision, there's a judgment of the Supreme Court, mainly Vijay Kumar Duggal and Vijay Dhar. It is saying when there is a head-on collision, contributory negligence of both the cars should be taken into account. Here, the accident occurred at Nelly Overbridge, Lordship. Accident has occurred at Nelly Overbridge. The stretch of the road in the Nelly is a straight road, sir. Lordship. There's no curve or no turning. This is from Jagir Road near Nelly and till Naga, it's a straight piece of road. So anyone going from this way, they can easily see whatever vehicle is coming from the opposite. And moreover, Lordship, in 2013, the Nelly road was already a 4-lane road, Lordship. So I'm not. I'm saying that my truck was not coming in the wrong way. It was the parked vehicle which was going on the wrong way. Even if my truck was coming the wrong way, then also the driver of this parked vehicle, he can see it from very far that
You hit on a parked vehicle.
Pardon?
You hit on a parked vehicle.
No, not the park. Spark. The car was a spark.
Acha.
Spark. The car. The driver of the car. No, I'm saying Spark, not Park as Spark. The car was of the Chevrolet company Spark.
Yes.
The driver of the car, he can see that the truck was coming from the opposite direction. If he has seen that the truck is coming in a wrong direction and is not coming in a rash and negligent way, so the duty is cast on him also to be careful and to avoid the accident. Lakshmi, in this regard, I could like to refer to the judgment of the Supreme Court in Vijay Kumar Duggal, reported in 2006, SCC 242. I have given the copy, Lordship.
Yes.
May I read the para number 12, the relevant portion? Adverting to the next contention of the claimant, no doubt the High Court has not dealt with the point in issue. However, we have noticed the reasoning and finding of MSCT recorded under issue number 2. In the evidence of Rajesh Kumar Gupta, PW2, who was traveling in a Maruti car along with the deceased Raj Kumar Duggal on the day of the accident, he also suffered some injury in the said accident. It is stated that while coming from Digboi, this accident also occurred in Assam only, Digboi. The Maruti car being driven by the deceased meet with the accident at a place near Khazanpur. Before the accident, Rajkumar Duggal noticed a passenger bus coming from the opposite side, and the movement of the bus was not normal, and it was coming in a zigzag manner. The Maruti car being driven by the deceased Rajkumar Duggal, and the offending bus has a head-on collision. In our case also, there was a head-on collision also. The MSCT has not accepted the evidence of PW2 to prove that the driver of the offending bus was driving a vehicle at abnormal speed. If the bus was being driven by driver abnormally in a zigzag manner, as PW2 wanted the court to believe, it was but natural, as a prudent man, for the disease to have taken the due care and precaution to avoid a head-on collision when he has already seen the bus coming from the opposite direction from a long distance. In our case also, the driver of the car, he has seen the opposite vehicle coming from a long distance because it's a straight road, piece of road. So he can easily see what vehicle are coming from the opposite direction for a long distance. It was a head-on collision in which both the vehicles were damaged, and unfortunately Rajkumar Duggar died on the spot. MSCT, in a view, has rightly observed that the knocking there being on one side of the car, the negligent resonance could not have wholly fastened or attributed to the driver of the bus. But when vehicle had a head-on collision, driver of both the vehicles should be held responsible to have contributed equally to the accident. The finding on this issue is finding of fact, and we do not find any cognate and convincing reason to disagree with Wells region order of the MSCT on this point. The MSCT has awarded increase at a rate of 10% of the amount of commission. Here, the Supreme Court has come to the fact that if it is a head-on collision, that there should be contributed negligence on both the vehicles. In our case also, it was a head-on collision, and the driver of the car, he has the opportunity to see the truck coming from a very long distance in the opposite side. And claimant admitted in the evidence and across also, it is a head-on collision. So there should be the contributing negligence of the car should be also taken into account, and the whole amount should not be fastened on our part, lawsuit. In this regard, I'd like to take your lordship on another judgment of the Supreme Court reported in 2008-6 SCC 767, Andhra Pradesh State Road Transport Corporation and others, plus K. Hemlata and others. Lordship got a judgment. May I read para 11, 12 to 11%, Lordship. To determine the question as who contributed to the happening of the accident, it become relevant to ascertain who was driving his vehicle negligently and rashly, and in case both were so doing so, who was more responsible for the accident, and who of the two has the last opportunity to avoid the accident. In case of damage that are to be apportionated, it must be found that the plaintiff fault was one of the cause the damage, and one of the conditions is fulfilled. The damage has to be apportionated according to the appropriate share of responsibility. If the negligence on the plaintiff part has also contributed to the damage, this cannot be ignored in assessing the damage. He can be found guilty of contributing negligence if he ought to have foreseen that if he did not act, this is important, if he did not act as a reasonable man, he might himself be hit, and he must take into account the possibility of other being careless. In our case also, the driver of the vehicle, he should have taken the, we should be careful that the truck may have come and hit him. Yes, he should have taken that precaution. He has not taken that precaution. So a little bit of contribution on his part also. The tribunal has noticed that the deceased was driving the vehicle at a high speed. Here also, they are saying that our vehicle was driving in a high speed with a view to attend marriage function. Manner of accident as deposed by the claimant witness indicate that the deceased was partially responsible for the accident. High Court was wrong in holding that deceased has not contributed to the accident, and there was no contributing negligence. Here the court has said the High Court has error has not taking the contributing negligence into consideration. So the Supreme Court has come to the fact that here also there is a contributing negligence, and there is to be contributed to the both the pay. So my humble prayer is that in this case also it is a head-on collision. So there should be a little bit of contributing negligence of the car vehicles, and the whole what I
And to prove the driving license.
yes, I'm coming to that. I'm coming to that. I'm coming to that. Lordship, this driving license. Regarding the DL lawsuit, the contention was that nobody from the DTO has come to prove that verification report. That was a contention. The claimant has not doubted the content of the verification report. The DL was not was that the report was not challenged, but the content was known as body as but the content was not challenged. Regarding yourself, this the paper I given to the lordship. It lordship, see, this was a RTI application lordship. Our ministry has done an RTI application. Based on this RTI application, the reply was sent. The original envelope I also provided to the. It was sent. Based on that, we got the reply. The verification report also was as a result of an RTI application lawsuit. So if it is an RTI replies lawsuit, RTI document is a public document issued by a public officer in discharge of his public function lawsuit. So it's not required to be again like someone has to come and prove it lawsuit. So there is no my first consensus was there is no requirement to someone to come and prove that document. As it was a RTI reply, then that document itself can be taken into consideration in the evidence plus. Second thing which I'll enter lawsuit. In this case, the owner and the diver. In this case, we have submitted specifically submitted additional WS also regarding the DL, and the owner and diver has not appeared, and they have not stated or not produced the DL lawsuit. In this, so lawsuit, I want to take lawsuit to a judgment of the Supreme Court reported in 2018 3 SCC 208, Papu and others, by Vinod Kumar Lamba and others. Relevant portion is 12 to 14 lawsuit. May I read it, lawsuit? This court in National Insurance Company and so has noticed the difference available to the insurance company under Section 149(2)(a)(2) of the Motor Vehicle Act 1988. The insurance company is entitled to take a defense that the offending vehicle was driven by an unauthorized person or person driving the vehicle did not have a valid driving license. Or this is important. The owners could shift on the insurance company only after the owner of the offending vehicle plead and prove the basic fact within his knowledge that the driver of the offending vehicle was authorized by him to drive the vehicle and having a valid driving license relevant. The owner has to plead and prove first. Then only the owner should shift to us. Here the owner has not entered appearance. They have not plead or proof lawsuit. The owners are not shift out. Even if the owners, we have taken the stand in WS, additional WS also we have given. We have taken a stand. After submission of the WS, the owner has not come and plead and prove that the driver was having a valid license. So we are not required to prove that. In spite that we have proved it by giving the RTI reply and giving the DW of the two of our officers lawsuit. The para 13, in present case, respondent 1, the owner of the offending vehicle merely raised a vague plea in the written statement. In this case, owner has entered appearance as filed the WS and submitted the DL also. Then also, in the present case, respondent 1 owner, the offending vehicle merely raised a vague plea in the written statement that the offending vehicle number DL was being driven by a person having a valid license. He did not disclose the name of the driver and other details. Besides, respondent 1 did not enter the witness box. In our case, the owner has not entered into witness box lawsuit or examined any witness in support of his plea. Respondent 2, insurance company in the written statement has plainly refuted the plea and also asserted that the offending vehicle was not driven by an authorized person having a valid license. We have also stated same in our WS, in additional WS. Was not driven by an authorized person having. Respondent 1, owner of the offending vehicle did not produce any evidence except a driving license of one Jogeshwar Singh, without any specific stand taken in the pleading or in the evidence that the same Jogeshwar Singh was in fact authorized to drive the vehicle in question at a relevant time. Only then could the owner shift, requiring respondent 2 insurance company to review the such evidence and to produce certificate in respect of offending trust was not enough for the respondent to make the insurance company liable to discharge his liability. Yes. As per this judgment, even if owner filed the WS and submit the DL, copy of DL in the WS, then also he has to enter the witness box and prove that this person was authorized and he has a valid license. In this first case, the owner has not appeared only, has not filed any WS. So we are the owners does not shift to us. Moreover, this was an RTI reply. So the tribunal should have considered our plea, and we should not, owner should be made liable to pay the compensation amount lawsuit. At least pay in recovery should have been given as per sentencing judgment lawsuit in this case. Second two, कोई भी? Second two, नहीं तो एक एक होता है. Lawsuit in the second case, my grounds are same ground. Just a little bit difference is there, which I should, little difference in the second case, owner has appeared. In the second case, the owner has appeared and filed a WS. That's the only difference. Other fact will be remain. In this case, the owner has not appeared. In the analogous, the second case, the owner has appeared and filed the WS. But still, even if he has appeared and filed the WS, he should come into the witness box and, as per Papu's judgment, he should come and plead and prove that say person was driving that DL was of that specific person and it was a valid light. Then only owner still should pay.
When is in a claim petition, in paragraph 23 of our claim petition, am I audible?
Para 23 of our claim petition.
Of my claim petition, in the second case, manager,
Or after.
that is Muninder Mohan Kolita.
Claim petition is not annexed along with the
No, no, it is in the LCA.
else here. You are on Muninder Mohan.
Yes. I want to show the pleadings of the parties with regard to contributory negligence. 2 points he have raised.
Page number.
Page number, paragraph 23, it's not numbered here.
Paragraph 23 of.
23 of my claim petition.
Yes.
On the fateful day, that is so and so, the injured was proceeding as an occupant from Nagaon side towards Guwahati on the left hand side of the road in a spark car. As the said car reached Nelly overbridge on NH road, all of a sudden truck bearing registration numbers so and so coming from opposite direction in a high speed came on the wrong side of the road and knocked the said vehicle. This is our pleading. And in WS paragraph 5, what they have stated.
Yes.
In paragraph 5, may I read, my lord? That the claim petition suffers from non-joinder of necessary parties, not maintainable in the present form, and is liable to be dismissed. The accident in question admittedly took place due to involvement of two vehicles where the spark car by which the victim was traveling at the time of accident had collided head-on with the vehicle number so-and-so truck. The accident in question took place due to rash and negligent driving of the spark car by its driver, and truck number so-and-so was non-offending vehicle. While owner and driver and insurer of the vehicle bearing registration number so-and-so had been implemented in the claim petition, the registration number and the names of the owner, driver and insurer of the spark car had not been disclosed and not made party. The answering opposite party number 1 being the alleged insurer of the non-offending vehicle, that is truck, is not liable to pay any compensation to the claimant. This claim petition is liable to be dismissed as against the answering OP number 1. This is their pleading. Now, in support of their pleading, there is no evidence that despite being it is a head-on collision, there was some negligence on my or had I contributed that the vehicle in which this deceased was traveling had contributed to the commission of the offense. There is no evidence as such. Therefore, I rely upon a judgment of the Honorable Supreme Court that is reported in 2020 3 SCC page 57. Mohammed Siddiqui versus National Insurance Company Limited, where in that case, my lord, 3 persons were traveling in a two-wheeler vehicle and they head-on collision with the offending vehicle on the middle of the road. The court said, in case of 3 persons traveling in a vehicle, there is a separate offense. There will be a separate proceeding against them to prosecute them. But there must be some evidence that must come from the insurer side to prove that by traveling 3 persons on a scooter or a two-wheeler, they have contributed to the commission of the offense. Therefore, the contributory negligence cannot be fastened upon them and was not fastened upon them. Same is the key issue here. They have set up a plea, but they have to prove by leading evidence that how I had contributed to the commission of the offense. Because in my claim petition, I said that he suddenly came from the wrong side and hit my vehicle. So that point goes, man. Secondly, the second part, my lord, that the driving license, fake driving license. The learned tribunal had rightly pointed out the maker of the document, the person who issued the that RTA reply, he was not examined. Apart from that, what is the law on this that is set up way back in 2004, my lord? National Insurance Company Limited versus Swaran Singh. There the law is what the Honorable Supreme Court has laid down, that if the plea is raised by the insurance company, the burden lies upon them to show first that the driving license was fake, and number 2, which is very important, that the owner knew it very well that it was fake, and thereafter he allowed the driver to ply the vehicle. Then only the burden will lie upon him. So in both counts, this appeal does not deserve any merit, liable to be dismissed. Same argument in second clause.
Lawsuit, as my learned friend has said, he has said regarding the contributory negligence, he has cited a judgment lawsuit. He said we have not adduced any evidence to prove their contribution lawsuit. In the judgment which I have submitted, it is said if it is hit on the side or any other side, then it will be a burden on us to prove that there is a contribution. But in the judgment which we have cited, it is said, as I have already said, they were aware that it was coming from us. It is taken if it is head-on, and the claimant himself admitted that it is a head-on. So admitted fact need not require to be proved. When it is already admitted, it is a head-on accident.
There is some difference. Head-on collision, admittedly, there is a head-on collision. There is no dispute about it. The question is for whose contribution or whose negligence. In fact, they have brought it that it was suddenly come from the wrong direction. They suddenly come, then it was an head-on collision. So that is
I understand. On that part, I said. Therefore, I said on 2013 it was a 4-lane was already there. So suddenly from that lane to this lane, the truck can't come. It was a 4-lane. If the truck is coming on a wrong path, it has to come from little bit up, and it will be seen by the driver of the car. 4-lane divider is there in the 4-lane lawsuit. So suddenly from that direction it can't come lawsuit. What they're saying is suddenly it has come and hit them. In 2013, that national highway route was already a 4-lane route.
The court cannot presume anything.
Whether
it was.
I'm not presuming. And it was straight. It was straight. It was a straight road. It was a straight road. So the driver, the second judgment which I given, the driver of the car, this is cast on him. If he has seen some negligence or wrong on my part, my truck part also, so it is on his part also to be careful and to try to avoid that accident. So if it is a head-on, some portion of negligence has to be there in the border loss. If it is hitting on the side or side, then it will
He is
be.
basically insisting on the question that it was a 4-lane road.
Right.
So it cannot be a case that the driver of the other vehicle who cannot see the other vehicle because it was a straight road. There was no curve at all. And that apart, it was a 4-lane road. That is his conclusion. There cannot be any case that the other driver came suddenly and hit the.
The sudden part I'm not disputing. I'm not.
That's up. You have
There
to
is
submit that.
nothing on record that it was a 4-lane. At which portion? Because at the threshold of a overbridge, we are everything saying on assumption. On a threshold of a
Nearly
overbridge. I do not know. There may not be any any divider. So those things they would have brought on record. Not even the sketch map that was exhibited. So how can this honorable court will presume that it was not because of the fault of that vehicle? And lastly, my lord, that Swaran Singh has judgment regarding the fake deal. That is judgment. The citation is 2004 3
Yes,
SCC
yes.
297.
297. Valuable.
In item number 16.
My learned senior is there. Some
In 16. Today I have some difficulty. If my learned senior allows me, can it be taken out?
I think 16.
16.
Justice. It does. Okay. ADS. Surrounding it's led. Yeah, okay, lot, very good. Yes, do you have any problem?
Yes, today I have something.
Mr. Gusan. With consent of the other side, Mr. Lachiti learned constantly respondent with pointed to their act. After vacation, it will be list the matter immediately after vacation as an edit.
I think item number 8, because of some water logging in my entire area, Lordship, I have some personal difficulty today. Your Lordship, kindly enough to whenever fix on next week, Your Lordship.
Item number
8. Already the matter has been adjourned for time being, Your Lordship. I could not reach the court on time because some heavy downpour in the.
So someone said this you're coming, I mean,
Lordship,
obviously there are some water logging.
Lordship.
So item number 8, you are appearing for
For one, claimant number 1, 2, and 3.
for the respondent.
For the respondent.
Mr. R.C. Paul is there. Is he here?
In some another election, another court. I will let them come, Your Lordship.
We can the R.C. Paul Ahanai.
Sanchita Roy, S. Roy, she will appear.
Acha, Astro will appear. They are not here. If you can inform, then we can, but it is of 2014 matter.
Lordship,
That's why.
that is why I will take on next week any date, Your Lordship.
You are Mr.
H. Purva.
H. Purva. মাত্র আপনি বললেন পূর্বা আছেন এর সরে consent one.
Already I have informed it, I will inform it. Already I have informed our phone.
With the consent of the others. Mr. H. Purva, the learned council, have been put it as number 153 paid for an item stating the his inconvenience due to sudden fluctuation. Prayer allowed is the matter. Next week we cannot say next week to Paribodan. Next week may not be possible next week. We were going to fix a date because it's a 2014 matter. So cannot see take over 14, 23rd of October. Listed at 23rd of October.
Well, I'm appearing in item number 15.
15.
My lord. Well, that is a, my lord, first appeal against, my lord, a decree which has been passed. My lord, I am being told, my lord, that these, there are some records which will be necessary in respect to a, my lord, matter which is going on in the NCLT, my lord. And the certified copies have not yet been, my lord, available. So can this matter be taken up immediately after the puja vacation so that, my lord, I can produce the documents which will be necessary for the adjudication of this matter, my lord?
Yes, Mr. Sahewala was there.
Yes, my lord, he appeared.
So he is submitting that some, he need to file some certified copy of documents, okay? Part Mr. G. Chaudhary, the learned, item number 15, the learned counsel for the appellant. And also heard, who is a
Lordship, I am for respondent number 4, Lordship.
4.
Lordship may kindly see the last order. Lordship may issue a reminder to the registrar. Our name may be strike up on the cause list. The last order.
Item number 15.
Samsung TN Industrial Company. তোমালোক এতিয়া নকৰা দাদা দাদা সেই NCLT certified copy কেইটা লাগিব কাৰণে মই কৈছো to be listed immediately after the puja vacation সেইকেইটা আনি পেলাই প্ৰডিউচ কৰা দৰকাৰ you have entered into a settlement share বিক্ৰী কৰি দিছে দাদা
তোমাৰ বিক্ৰী কৰে গাড়ী বিক্ৰী কৰি
So you have withdrawn your Bakarat.
Lordship, reminder, we have given notice to the respondent number 4, also have sent notice to him also.
Have you furnished a copy of the notice before this court also?
No, Lordship, not yet. The
Have
last
it
direction was there to registrar was directed to strike up our name as per the last order.
But otherwise, earlier you appeared for respondent number 4.
Lordship.
So now is there anyone appearing?
No, Lordship. We have instruction to withdraw Vakalatnama and accordingly we have petition. So our name may be kindly strike up on the cause list.
Earlier one, Mr. T.H. Hazarika.
Lordship.
You are.
No, Lordship, D. Roy on behalf of T.S. Hazarika.
And again, one A. Rashid.
A. Rashid, D. Roy, K. Islam.
K. Islam. D. Roy. 4 advocates were there.
Yes, Lordship.
But the notice you have already issued to your client or respondent number 4. Is there and thereafter any communication was there with you or
We can
they
produce it on
accepted?
the next date. We can produce it on the next date.
Just produce your notice
Yes.
because actually some verification is required as because you are entrusted with some Vakalatnama.
Yes.
That is the only consideration. That's what I'm
We
asking.
include a Vakalatnama with the application. If
You
required.
want to withdraw it, but it has to be allowed, na?
The
That's what-
the instruction from our client is to not appear in this case.
Your Vakalatnama has already been withdrawn.
Lordship.
D. Chaudhary, Lillian, and also had Mr. Jane Sullivan, the learned senior appearing for the respondent number 1, 2, and 3. Assisted by Mr. H.K. Shah. It is submitted by Mr. Chaudhary that he has already applied for some certified copy for the proceeding which is pending before NCLT. And the two certified copies of the will be required for the hearing this case and according paid for an adjournment. Mr. Sahiwala, he is appearing, praying for an adjournment if you wants to supply some certified copies.
But he said that some settlement, I don't know whether I have no information. Immediately, well, that may be.
Sir, after the puja vacation,
That will be on
further.
December
16th
Also
October, well,
heard Mr. D. Roy, the learned
16
counsel
October,
for
no,
the respondent
sir,
number 4.
24
He submitted that earlier occasion,
Friday. Oh, yeah.
the prayer was made for striking out,
Detail
the
30
delete- striking out, deleting the name
30
of
October.
the respondents who are appealing for the respondent number 4 as they have already withdrawn their wakalat and the court prayer was also allowed. The registry was directed to the it. However, in spite of that, the name has already been reflected to the court. In view of this, the registry is accordingly directed to check out the name of Mr. P.H. Hazarika, A. Rashid, A. Islam Yadasa Namita, and D. Roy from the cause list. Name and name may be struck from the cause list. Click it. Now, regarding their engagement with the other council, you don't have any
No, Lord.
information.
No, Lord.
Then again, it will create an problem. Respondent number 4, they were appearing earlier, but now they have withdrawn their.
Actually, as per the law now, what will happen, my lord, because now they have withdrawn from this case, a notice will have to be issued from the court
Now
to
they are,
that respondent
yes,
number
yes,
4.
now they have issued, they say,
they have already, they have said that they have already
that
issued.
copy should be filed before the court.
You file a notice before this court.
Yes, that is
That
the,
will be better.
The petition, Mr. Counsel, the land counsel for the respondent, Mr. D. Roy, is accordingly directed to produce the notice which were furnished to the respondent number 4 before withdrawing their. Further, the registry is also hereby directed to issue notice on the respondent number 4 to be studied and as their process. It is the matter 16 October, you say
it is, let it be on 30th of October, 30th,
30.
30.
List the matter accordingly on 38 of. Otherwise, respondent number 4 is also a necessary party.
Necessary particular.
Then
Because the shares relate to the that particular company.
whatever, if it is
Yes,
there,
they are necessary.
please stop with it. But, yeah. Okay, well, listing will do the.
My lord, my lord.
On
I'm
take
sure.
it also, you just produce the notices.
My lord.
Wait,
Yes.
please, your lordship.
Just a second. The other side.
I'm there.
Oh, acha. It is what case? I mean, company is not here. Company is not here. Oh, no, name of. Acha, so you are one of the na Miss Baby Paul and White. Okay. Yes, Mr. Khan.
Lord. Appeal filed by the appellant claimant Miller, original claimant Miller for enhancement of compensation. Three grounds basically Miller, 6,500 was taken as monthly income Miller. He was the owner of a truck and was possessing a driving license to drive heavy motor vehicle also Miller.
Second, my lord, the rate of interest, my lord, was granted at the bank rate without specifying the rate, my lord. And third, my lord, interest was paid from the date of the filing of the evidence on affidavit, not from the date of the filing of the claim petition. These are the three grounds for appeal in this case, my lord. Now, if your lordship, we have supplied the paperwork on the previous occasion, lordship has, my lord, that paperwork in the file. File the paperwork in the yes, all the copies now.
Remove the same.
असली किती लोक yes more दुसऱ्या कॉपी असेल की मला आता प्रश्न पासून दिली बोल this paper book is there right
No, he did that.
you can have this copy me
Did not. They did.
it copy did okay
No, I can take your copy, but subsequently again it will be required. now.
you can
You have
go through the
furnished
record.
it before the court.
That's it
It is here with the record.
on the previous occasion hearing was Milord, it was listed before Justice Goswami, Kaushik Goswami, we have submitted the copy paperbook on this paperbook there. It is not there, Milord, Lordship can have that, or Lordship, we can go through the records also, Lordship can. There are 3-4 annexes only, Milord. We can refer to the
Yeah,
annexes
well,
also.
answer. Wait to tell okay, Purva. Section of community to get a something. And nothing. Have a furnished copy to Mr. Goswami. You
I
have.
have only one copy was already furnished, this copy is one. We can give him my copy at the time of hearing. Lord. You can refer to it, Milord. It will become just convenient. Lordship, take
এইটো পেপাৰ বুকটো তেখেতসকলে যোৱাবাৰ দিয়া বুলি কৈ ইয়াত দেখোন দেখা নাপাওঁ।
we can go to the original record also, Lord. Both options are there. Original record are there.
Otherwise, if you go by this one, then Goswami will have some.
But we'll furnish this copy at the time of his hearing. My copy is there, Milord. And we are only 3-4 indexes, not much, Milord. Lordship, I have no difficulty. In both ways, I have no difficulty.
Okay.
Milord, evidence of the claimant is at page from page 25, Milord. And Lordship may kindly see, Milord, that the annexes, Milord, we have that exhibits, Milord, that we have annexed. It starts from page 32. Lord, relevant annexes would be, Milord, page 43. Sorry, Lord, it will be page 44, Milord. Page 44, if Lordship has, Milord. Driving license. Driving license. ठीक है ना अपना ऐसे driving license. Lordship has page 44, Milord. Lordship, it is a driving license, Milord, of the deceased Sisram Chaudhary, Milord. He is authorized to drive, if your Lordship please, LMB, MB, and HMB, Milord. Medium and as well as heavy motor vehicle, Lordship. And it was valid, Milord, on the day of the accident. It was valid up to 21/3/2016. Date of accident is 7/7/2015, Lordship. $46, Milord, is the registration certificate of my truck, Milord. It is registered in the name of, Milord, the deceased. Page 46, Milord. Page 47, Milord, is the permit issued from the Regional Transport Authority, Kamrup, Guwahati, Milord, of the for the truck, and it was valid, Milord, up to it was valid up to 3/7/2016, Milord, the permit. Date of expiry 3/7/2016. Again, fitness certificate, my lord. It was valid till 6/7/2015, my lord. And the insurance policy is page 49. Your lordship takes up the insurance policy, my lord, and premium of rupees 100 was paid for PA cover for honor driver. And it was a package policy, my lord. All I want to prove by this document is that on the day of the accident, I was running a truck, my lord. I have a driving license to apply, and the learned tribunal took 6,500 saying I'm a businessman. My income was not proved. There are three aspects of matter, my lord. One, when we could not prove our income or the mode of occupation, my lord. Minimum wages is taken into consideration. When we can prove our income, my lordship, but cannot prove our mode of earning, my lord. In such circumstances, if the income is proved, the court has to take the income into consideration, my lord. And in cases where mode of earning is proved but income is not proved, then, my lord, comes adjunctive calculation, my lord. That in this case, that I am the owner of the truck, my lord, is proved. I possesses a valid driving license to drive the vehicle is proved. In that circumstances, my income should match with the any owner of a truck who drives his own vehicle, my lord. That is my first submission, my lord. For that, I will submit some case laws, my lord, in the matter. Respond copy कीजिए हाँ एक respond जरा एक लगता है ये तो हमारा टाइम लगेगा एक in this here below one Tripura High Court in 2001 has held a truck owner will earn 9,000 2001 below 2015 it was held 2009 it was held 15,000 below. Here I am both the owner and driver. So my submission is, and I have asserted that my income is 30,000. I have a school going son and a wife below. The first judgment is of the Madras High Court, my lord. If your lordship take the paragraph 4, my lord, for a moment. May I read? On a careful consideration of the contention of the learned counsel for the appellant, it could be seen that almost in 70 to 80% of accident cases, the claimants are not able to produce any evidence with regard to the income of the deceased. Only in cases of employed person, we can expect the salary certificate, or in some other cases, he is an income tax assessee, we can accept some evidence with regard to the income of the deceased. If a person who dies in the accident is self-employed and not an SSC, in those cases, the tribunal as well as this court has to proceed to find out the income of the deceased on the basis of the nature of the employment of the deceased. In this case, the deceased has been selling Rafael tickets on hypothetical basis. The tribunal fixed rupees 1,000 as monthly income. So where mode of earning is proved, assumptive calculation has to be there. Now that second judgment, lordship, of the Calcutta High Court, my lord, if your lordship takes up the first paragraph, it's, my lord, case of the appeal is the instance of the appellant under section 161 directed against the award dated 30 April 2003, passed by the learned so and so motor accident in MSC case number 329 of 2001. 2001 the accident occurred, my lord, and paragraph 13 is the relevant paragraph. May I read, my lord, 13?
Which Kolkata?
Kolkata High Court. It's a case of accident of 2001, my lord. Para 13, my lord. As regards the income of the victim, there is no dispute that he was a truck owner carrying on business of transportation and used to drive.
Here, Supreme Court, then Guwahati,
Lordship.
then New Delhi, Kolkata. Oh, yes, yes.
Lordship.
Para 13.
Paragraph 13. Calcutta High Court, my lord, in Krishna De case.
Yes.
May, my lord. As regard to the income of the victim, there is no dispute that he was a truck owner carrying on business of transport and used to drive the vehicle himself. without engaging in that. The widow of the victim is specifically asserted the monthly income of the husband was 9,000 a month. It appears although the insurer of the vehicle owned by the victim gave a vague suggestion in a cross-examination denying such fact, the National Insurance Company, the insurer of the other did not put any suggestion to the widow of the victim disputing her claim that her husband's income from the business was 9,000 a month. Moreover, the owner of a truck who himself drive for saving the salary of a driver quite reasonably earned 9,000 a month, and therefore the state amount cannot be said to be unreasonable claim to disregard the said statement as unworthy of credence. In this case also it is 2001, Milord, where the accident here occurred in 2015, after approximately 15 years, Milord, and my claim is only 30,000 rupees, Milord. So in this few, Milord, we are stating that that has to be accepted, Milord. The third is, Milord, of the Delhi High Court, Milord. Here the owner of the vehicle, Milord, owner, not the owner driver, Milord, was given 15,000, Milord. Second paragraph, the insurer questions the award on the ground that Lordship has the Asfari waiving case, New Indian Insurance.
Yes.
Paragraph 2, Milord. The insurers questioned the award on the ground that the loss of dependency was wrongly calculated on the income of 15,000 with the element of future prospect of the increase in income to the extent of 30%. Having heard the learned counsel for the insurer and having gone through the record, this court find no substance in the question raised on the finding of income of the deceased. The deceased, it is proved by the owner of a truck and earning his livelihood from transport business. The evidence clearly shows that he was paying equated monthly installment to repay the loan taken for the purpose of the said vehicle. In this circle, the finding on the issue of income is not disturbed. Now, here, Milord, the court took income of 15,000, Milord, per month, Milord. Next, Bajaj Alliance case, Milord, here it's a case of driver, Milord. The driver, a commercial driver in 2009, it was said 12,000 salary was on paragraph 5, Milord. Learned counsel for the appellant submit that it was the case that the appellant, the deceased, was 36 years of age and was a commercial driver getting a salary of rupees 12,000 per month based on the testimony of the employer PW2, who said that it was employed by his company and in the year 2007 was getting a salary of 11,000 per month, and this was enhanced to 12,000 per month in 2008. The tribunal accepted the salary of 2012 of 12,000 per month. Future prospect of 50% was added to the income block. Now, this award was challenged, and paragraph 9, Milord, with the relevant portion, page 4. There is no reason to disbelieve the said submission of the said witness. It is difficult to accept the contention of the learned counsel of the appellant that a commercial driver would be paid for driving a commercial vehicle only rupees 4,000 per month at the rate. At this rate, even in 2009, it is hardly possible to get a trained driver for commercial vehicle, Milord. Then insurance contention was that 4,000, Milord, was they are getting 4,000. Here, the Delhi High Court accepted 12,000 rupees in 2009 for the payment of driver, Milord. Then last judgment is of Gurpreet Kaur, Milord, on the judgment of the Supreme Court, paragraph 8 and 9. Here 25,000 was calculated, Milord. He was the owner of a truck, Milord, or owner of a tractor, Milord. Paragraph 8, Milord. Of Gurpreet Kaur case, Milord, to 2022 SSC online 1778, Milord.
Yes.
Though there is no evidence on record regarding the income of the deceased pricing, however, from the testimony of PW4, it is clear that the deceased was regularly making the payment of rupees 11,500 an installment and discharge his loan liability towards the tractor. At this rate, the entire loan was paid back within a year or so. This clearly established the earning capacity of the deceased. It is also the case of the appellant claimant that the deceased was working as a contractor for earning 50,000 per month. The tribunal adopted a balanced approach, keeping in view this factor. The payment of the monthly installment of rupees 11,500, taking loan of the tractor, maintaining a family comprising of two minor children and parent, affording tractor and motorcycle, that the deceased was working as a contractor, assess his income at 25,000 per month. In our considered view, the tribunal approach is quite justified in law as well as on fact. in the summary proceeding where the approach of the tribunal determination must be in conformity with the object of welfare legislation. It was rightly held that the monthly income of the deceased could not be less than 25,000. The region assigned by the High Court to reduce the monthly income of the deceased is totally cryptic and has no rationale. The notification of the Minimum Wages Act can be a guiding factor only in case where there is no clue available to evaluate the monthly income of the deceased. Where positive evidence has been laid, no reliance on the notification could be placed, particularly when it was nobody case the deceased was a laborer as presumed by the High Court.
So basically, you have taken 2, 3 grounds.
Lot it.
That is mainly on income.
Income and interest part, that is the only two ground.
Income and
Income and the interest part, Lord. Interest was not given from the date of
interest
the
part was not.
Lord. On these two, Lord.
Okay, I'll just pass.
Lord. Uttam Ravidas Milord case. Paragraph 6. This is the last judgment so far as the income is concerned. Lord.
Uttam?
Uttam Ravidas Milord. But Sigdal Rahman.
Of our division bench of this court.
Division bench of this court. By Justice Ansari and Justice Baipi Milord. I think we can give it.
Yes, yes.
Lord,
Uttam
we have
Ravidas.
Yes. Paragraph 6, Milord. Ma'am. However, in view of the fact that the documentary evidence was not available on record, the learned tribunal treated the monthly income of the claimant as ₹1,000 per month. We may point out that it may not be possible for a person to prove his monthly or annual income by production of documentary evidence, hence merely on the ground that no supporting documentary evidence has been produced, the unassailed evidence of the claimant as to what his occupation and income at the time of the accident was should not be discarded. Lordship can see the cross-examination partner from the paper book, page 29, Lord. See the cross-examination of the same. Lord. Page 29 of the paper. Lord. On behalf of 1 and 2, my husband was doing many old business during his lifetime, including contract work. I did not see the accident. I did not know the criteria for payment of income tax. I do not know whether my husband was accessible to income tax or not. It is not a fact that I have deposed falsely in regard to the income of my husband. I do not know how the accident occurred and I did not see the same. I do not know whether there was no fault of the vehicle number so and so. It is not a fact that the documents which have been submitted by me in this case are false and fabricated and not connected with the accident. I did not know if different PSKS number are mentioned in Exhibit 1 and Exhibit 3. It is not a fact that the vehicle number so and so was not involved in the accident, etc. I am not entitled to any compensation from the insurance company. It is not a fact that I have not submitted any document to prove the income of my husband. It is not a fact that I have stated falsely that my husband was earning 30,000 per month. So nothing has been brought on cross-examination without. And Lordship can see without that we have annexed the documentary evidence with regard to my son's education without, which is at page. Only one document that has also not been disputed. Page number 50, Milord. My son was studying in class 9, Guwahati Refinery School, Milord. And page number in the evidence, Milord, that has also not been disputed. You could also pick up the evidence on affidavit, Milord, page 25. page 25 to 28, my lord, evidence and affidavit. And I've stated at paragraph 6, my lord, page 26, my lord, that I state that this is has to incur expenditure on the education of the minor son, namely Sandeep Kumar Chaudhary, the claimant number 2, which includes the educational expenses as well as expenses on various amenities of his son on the day-to-day. It mentioned that we are resident of Lokra, whereas my son studies at Nunmati, and has a substantial amount has to be incurred for his traveling to school, my lord. So, these are the facts, my lord. No direct proof of income is there, but we have a substantial evidence, my lord, to show that I was earning, maintaining a family, was having a means of income, my lord. So in that background, let truck owner, any driver, the minimum income that can be calculated is 30,000, my lord. He will earn much more than 30,000 in a month, my lord. The owner of a truck who drives himself, my lord. That is my submission with regard to the income, my lord. Now, lordship may kindly see the source for the interest part, my lord. What the learned tribunal did, they calculated the interest from the date of the filing of the evidence on affidavit 1. They did not, my lord, fix the rate of interest. They said prevailing bank rate, my lord. That is, in my humble submission, there is no case law I have got, but not permissible, because the court has to come to exact finding. If the bank rate is 7%, let it be 7%. If the bank rate is 8%, let it be at 8%. Some evidence has to be there on that part, my lord. So on that part also, the learned tribunal, in my humble submission, has erred, my lord. If your lordship takes up the citation, some of the citation that we have provided, my lord, why Bombay High Court judgment is very relevant, my lord. It defines interest. What is interest, my lord? The first judgment is the Oriental Insurance Company versus Niru and others, my lord. 2025 SSC Online 1431. Paragraph 10, my lord, page 4. We cannot but observe that there was nothing stopping the insurance company from settling the claim on a computation on receipt of intimation of the action, especially since the determination of compensation for loss of dependency on death with occasion in a motor vehicle accident can be determined as evident from the judicial precedent, at least provisionally. In fact, it is due to the repudiation or refusal to consider the claim the claimant are driven to the tribunal, where the matter is pending before the tribunal or in appeal before the higher form. The claimant are deprived of the compensation for future prospect. If they are paid in time, it could be utilized by the claimant, and on failure, the loss of dependency would force the claimant to source their livelihood from elsewhere. This is sought to be compensated at least minimally by award of interest, which oftener than ever is nominal. Also, since only simple interest is awarded, there is a bar of 171 million simple interest, compound interest does not come. If the amount were disbursed to the claimant on a rough calculation, on intimation of the accident to the insurance company subject to the award of the tribunal, necessarily there would not have been any interest liability, at least to the extent of the disbursement made. Hence, we reject the contention and direct the entire award amount would be paid with interest at the rate of 9% from the date of the claim till the date of disbursement, deducting only so and so granted the interim compensation so and so. So my submission is, my lord, not granting interest is giving premium to the insurance company, my lord, for holding the money of the claimant, my lord. If they could have come and at least said this, okay, the 10 lakhs of claim, we will settle it for 5 lakhs, pay us 5 lakhs, the interest company itself will go down. But insurance company keeps our money, then they contest for the interest part also. Interest, again, my lord, is paid only on simple interest, my lord. That is there, my lord. Now, Bombay High Court next judgment is there, my lord. The Bombay High Court lordship has explained interest. It was a case of pensionary benefit, why interest was paid, my lord. Page 6, lordship, paragraph 18 onwards, my lord. How the concept of interest has come in, my lord, that has been explained here, my lord. Page 6, paragraph 18, my lord. Subpara 16, my lord, quoting the Honorable Supreme Court, my lord. Yes. The concept of awarding interest on delays, I'm reading para 16, my lord, of the Supreme Court here. The concept of awarding interest on delayed payment has been explained by this court in the case of so and so, so and so, so and so. It may be mentioned that there is a misconception about interest. Interest is not a penalty or punishment at all, but it is a normal accretion on capital. For example, if he had to pay B a certain amount, say 10 years ago, but he offers that amount to him today, then he has pocketed the interest on the principal amount. Had he paid the amount to B 10 years ago, B would have invested that amount somewhere and earned interest thereon. But instead of that, he has kept that amount with himself and earn interest on it for the period. Hence, equity demanded he should not only pay back the principal amount but also the interest thereon to be. This way, thus, where a person is deprived of the use of his money to which he is legitimately entitled, he has a right to be compensated for the deprivation, which may be called interest or compensation. Interest is paid for the deprivation of the use of money in general terms, which has returned or compensation for the use of or retention by a person of a sum of money belonging to the other. As per Black Law Dictionary, interest is the compensation fixed by agreement or allowed by law for the use or detention of money or for the loss of money or one who is entitled to its use, especially the amount owed to the lender in return for use of his borrowed money. As per so and so, interest means entirely compensation paid by the borrower to the lender for deprivation of the use of the money. So this is my submission, Lord, that they have kept my money which I was entitled to on the date of the accident. So naturally, my lord, even if some delay has been caused on our part, my lord, then also my money has remained with them. They have earned interest on that. That interest I cannot be legally denied. No, third judgment is Lordship of Supreme Court. Again, my lord, here paragraph 3, page 3, my lord. Here it says, my lord, that what should be, whatever be the interest rate, my lord, it should be paid from the date of the compensation, date of the accident, date of the filing of the claim petition.
Para 3.
Para 3, my lord. The tribunal has awarded interest at the rate of 6% per annum from the date of the award, but the High Court chose to curb 3% per annum. In the first place, we do not appreciate the reasoning of the High Court to reduce the rate of interest. We also see no justification by the court below of not having awarded interest, whatever be its rate, from the date of the application. The way the inflation has galloped in the past 2 decades and the value of the rupee eroded, we see no justification why interest the rate of 12% per annum was not awardable in the instant matter. We therefore award so and so. Again, the second judgment also, it says that whatever be its rate, it should be paid money from the date, paragraph 2. Srimati Chameli Vati case, 1986 Supreme Court. Paragraph 2 is not the
Para?
Paragraph 2, my lord.
2.
Paragraph 2. There's bold portion, we have bold it, my lord. The learned single judge as well as division may totally ignored the fact that the enhanced amount of compensation awarded to them was in their judgment the correct amount of compensation payable to the appellant on account of the death of the deceased resulting from the accident. The learned single judge and the division bench should have therefore awarded interest on the enhanced amount of compensation from the date of the application. We accordingly set aside the judgment of the division bench as also the judgment of the learned single judge. So far as the judgment direct that interest shall be payable on the enhanced amount of compensation from the date of the respective judgments. So it should be from the date of the filing of the claim petition. Now, rate of interest, my lord, that 2 judgments are there, my lord. One is Amresh Kumari, my lord. It is also paragraph 2, my lord, page 2. The question whether interest on the amount of compensation determined to be payable to the claimant is to be awarded from the date of the award or from the date of filing of the claim petition came up for consideration before disclosing so and so, to which was the party. It was held that claimant was entitled to interest from the date of the filing of the claim petition. And Guwahati High Court has held, my lord, that quoting paragraph 17, page 6, Puspa Maheshwari case, my lord. Here 9% interest was granted, my lord, by the Honorable High Court, quoting the Supreme Court case, my lord. Both the tribunal granted interest at the rate of 7%. The claimant also prayed for enhancement of interest, placing reliance on a decision of the apex court in so and so 2015 to SSC, my lord, United Indian Insurance Company, company so and so, and Srimati Gulab so and so. Following the principle laid down in the above decision as well as the mandate of the apex court in Narendra Singh Nishant and Nishant so and so case, where the apex court observed further an interest the rate of 6% per annum on the compensation was awarded by the tribunal, which was enhanced to 7.5% by the High Court. The interest is determined by both the court below are bad in law as per the legal principle laid down in MCD versus Upahar tragedy victim case, my lord, wherein this court has awarded interest at the rate of 9% per annum on the compensation awarded in favor of the appellant. Applying the same legal principle, we grant interest at the rate of 9%, my lord, on the compensation, my lord. This is my submission, my lord, on because here's the one more point thing I may point out, if lordship sees, my lord, that the learned tribunal also in the judgment has held, my lord, that if the award is not satisfied within 3 months, 1% additional income will interest will be levied, my lord. They have not satisfied about judgment within 3 months, my lord. It was satisfied much after 3 months, my lord. So as per the tribunal, if in terms of tribunal judgment also, we will be entitled to 9% interest, and it should be from the date of the filing of the claim petition. That judgment, the observation of the learned tribunal is lordship. May I just point out lordship can say page 12, my lord, of the appeal, my lord, appeal memo. This is the income part, and thereafter it has come with the judgment, my lord. Judgment is in the paper book also, lordship.
Yes.
Paragraph 20 of the judgment, my lord. If you lordship is taking at the paper book, it will be lordship has paragraph 20. Now coming to the question of income of the deceased, the claimant in her evidence stated at the time of the death of her husband was a businessman and monthly income was 30,000, but the claimant has not proved the income of the deceased. And in the absence of any positive evidence of the income of the deceased, and considering the present state of economy and price, 6,500 per month is taken as the income of the deceased for asserting the loss of dependency, as it cannot be ruled that an able-bodied man would definitely earn minimum 6,000 per month for his livelihood. Now, interest partner 1/3 was given. Now, you can see award, paragraph 27, award and order. Paragraph 27, page 14. Accordingly, the National Insurance Company directed to make the payment of so and so within a period of 3 months from today. The compensation amount shall carry an interest the bank rate for fixed deposit from 3 to 2017. Record revealed that the case was filed by the claimant on 4/9/2015, around 3 years back, but the claimant could adduce evidence on 3/2/2017. As such, I do not find any reason to direct the insurance company concerned to pay interest from the date of the filing of the claim petition per annum. And in the event of failure to make the payment within the stipulated period, the compensation amount shall be an additional interest at the rate of 1% per annum from the date of the filing of the claim petition. So they have not deposited the amount within 3 months. And that is also there.
Some observation was made
That's
while
it.
calculating the part, that date of filing or date of the order, there was an observation was made that why it has to be from the date of.
Yes, observation was made, but the law says it has to be from the date of the application. Even there are other judgment of the Guwahati High Court Division Bench also, the reason is it's my money and my entitlement comes on the day I met with an accident. And if you just take up 171 for a moment, motor vehicle act, of the motor vehicle act, and the delay parts of what Which time look evidence was moved. 6 months, no? Lordship, one more aspect, Lord. We filed the case on 4/9/2015, my Lord. The WS was filed and issues were framed, my Lord, after 286 calendar days, my Lord. That is on 16/6/2016, my Lord. 16/6/2006, we were up to file our first evidence on affidavit. We filed our evidence on affidavit on 16/12/2006. After 6 months, 183 calendar, only 6 months of adjournment was taken by us for filing 2 witnesses, my Lord. Thereafter, my Lord, the insurance company took adjournment, my Lord, for 1 year, 1 month, and 16 days, my Lord. After that, for reducing defense evidence, my Lord. From 17th 2017, my Lord, to 17, yes, it is. 17, 2nd May 2018, my Lord, they took adjournment, my Lord. So they took 1 year, 1 month, and 16 days to reduce defense evidence. They took 9 months, my Lord, for filing WS, my Lord, and we took only 6 months, my Lord, to reduce the evidence of 2 witnesses, my Lord. So Lordship, all the blame has been by the tribunal has been put to us, my Lord. That is also not fair, my Lord. Now, if you Lordship take the 171, my Lord.
Thank you. One
171, my award of interest, my Lord. Where any claim tribunal allows a claim for compensation made under this act, such tribunal may direct that in addition to the amount of compensation, simple interest shall also be paid at such rate and from such date, not earlier from the date of making the claim, as it may specify in this behalf. And 158 subsection 6, my Lord, it says that whenever an accident takes place, the officer in charge of a police station is obliged to inform the tribunal who has to register it as a claim. So just after the legislature intention, in my humble submission, is that, my Lord, that the moment the accident happens, it has to be registered, and thereafter the interest has to be paid, my Lord. That has been reflected in the other judgment.
This practice is going on now at present,
Lordship?
because I know that regarding the registration, whenever if any accident is happened, then definitely the duty of the as well as the police officer to register the case.
Earlier it was not there, my Lord. Earlier it was not there, but you know, the law was still existed on earlier time. The legislature has inserted section 171 after 158. So we can presume that it was taken in 158 subsection 6 was taken into consideration while drafting that 171. That is my humble submission. Subject to what my learned friend. That is my humble.
Please, Your Lordship. I have a very short submission. The first thing, I'll come from the last. This judgment was satisfied, Lordship, may not be exactly within 3 months, but it was within 4 months, it was definitely satisfied. This was paid on Lordship. I have the exact check number and date. Let there be no impression that we had delayed the money. This was paid on this date. Date person apna more. Lord, it was received by the MSCT on 26/9/18. 9/18, Lordship. It's not a big delay because the judgment was passed on 10/5/2018. More or less, Lordship. Considering the scenario that prevails everywhere, it's almost in time. Something like that one says in Panor Pasun Khohan, little bit of it. As regards Lordship, I'll come to the other point, Lordship. Income, Lordship. In fact, all the judgments my learned friend had submitted, I've seen one thing is common. They had all adduced some kind of evidence. That Your Lordship, in some cases, what was the payment to the bank is also discussed. What is the repayment, EMI, etc. are discussed. Let's say just because one buys a vehicle, and one thing, actually, one thing I need to clarify, he was himself not driving. On that day, so one Rajan Sharma was driving.
On that day, but he was in that truck.
So we have to go by what happens. Maybe he has a license, but he was not driving. Factually, I'd like to make it. He has to pay the driver also. From whatever income he earns, he has to pay the driver. So not, I don't know, it was a small truck, mini truck, 407 truck. Its capability for repayment also has to be considered. But what was easily possible for the claimant to do is to submit a copy of the bank passbook, which will show reflection of the EMI payments as well as his earning is also reflected in the bank passbook. A person who earns sufficiently will deposit something in the bank. Person, there's no such evidence at all. The questions that were put to the it was just denied that suggestions were denied, and what could the insurance company have done? We could not have got a copy of his passbook or a copy of the statement repayments made to the financer. So it was entirely up to the claimant to prove his credentials. Like I'm making monthly 10,000, 15,000 EMI repayment, or these are my accretions to the bank. If a person has something to spare, he would have definitely put it in the bank. There's no bank. That was easily possible. Everyone has a copy of the passbook that could have been given by way of bank statements. So, and in any case, Lordship, 30,000 would have attracted income tax. If he wants to claim legitimately as 30,000, he should have produced the income tax return. So that part was not the Lordship proved at all. So I mean, claiming 30,000 or even 25,000, I think it was at best a case of a businessman who may not have been successful. There are a lot of vehicles, Lordship, which are seized by the financiers. These stories that Supreme Court judgment also, why vehicles should not be seized by employing Lordship this muscle man. So it's not that every vehicle owner becomes successful in it. So some proof was required to be given, that was not given. So Lordship, a lot of about his income being 30,000. That will have reflected in some. There's no reflection. So maybe he has a case for a marginal increase, but not to the extent my learned friend is there. I'll say yes. He is a vehicle owner. Possible not. He might have been earning losses also. No one knows. Lordship, as regards the, I'll leave it to a Lordship. It's something he has utterly failed to prove income. So maybe not 6,000, maybe something more, but not to the extent my learned friend. There's nothing to substantiate that income. As regards Lordship, I agree with him that yes, in this case, the facts suggest that income, interest should have been given from the date of filing the application. That is a settled part of law. It's never from the date of application or date of accident. It's like in WC cases. Very clearly, in WC cases, it's always from the date of accident because everything is in a kind of formula. One can calculate and give it. Here also, he has to file the application. Sometimes applications are filed years after. So that cannot be as a principle was laid down. It's an accepted law. There is judgment to that effect. I can produce a judgment to see which very clearly says in motor vehicle accidents, interest has to apply from the date of filing of the application, not from the date. I've agreed to his Lordship. Yes, maybe there's some that promptness was not there. Like he has pointed out, I'm presuming those facts on face value. Interest should be given from the date of application in this case, not in all cases, because there are justifiable cases when interest cannot be given from the date of filing because sometimes the claimant was sleeping for a long time. It takes they come to the court years after filing the claim application, come with the evidence. So, but this is a case here. As regards the interest part, Lordship, what is the rate of interest? That's a settled part of almost position. There's one very judgment, unfortunately, I misplaced the Kaushal Begum versus New India Insurance Company. It is very clear. There's one judgment which has discussed what should be the interest. Otherwise, most of the judgments, Lordship, without even a one-line discussion, interest applied at 7. It varies from 6% to even the case my learned friend has given. First case, Supreme Court, 6% is given, and 1% permanent. This is the case.
Last page of-
Yes, last case. The first case that he had given Supreme Court, 2025. Oriental versus Nehru.
last page of-
Last page, I think. Last page. And interest, this was upheld, interest at the rate of 6% was upheld. And in default.
Which one you say?
No, sir. This is the judgment my learned friend has given, Oriental versus Nehru, is from his compilation.
Nehru.
2025 SCC online, SC.
No, no, just wait.
Yes, I'll need to enter.
It's 9%.
Granted SLP and as before, reduction payment made immediately, yes.
No.
And so reject the consent and the entire award amount should be paid.
9%.
9% reject to it. And granted.
And direct that the entire amount would be paid with interest at the rate of 9% from date of the filing of the claim till the disbursement. Deducting
Yes, in
50,000
Nehru,
grant of
you're
interest.
saying that in Nehru, it was 6 plus 1, 7%. Yeah, where it is.
Granted intervened in SLP, deducted my granted assessment and I think 6% was something. I'll read it again. Lordship, I just need one. And so reject the contents and direct the till the payment exactly only. Iman and in there are 2 cases.
So here that the direct that the entire award amount
Hmm.
would be paid with an interest at the rate of 9%.
Excellent. Lordship, there are also judgments to the effect that interest, different rates of interest is given. One up to the, in this case, is paid up to 2018. That means the entire interest has been paid, whatever was there, that was given. So anything over and above, Lordship, there is different rate of interest also applied. The 2 interests, one is up to the date of judgment, and beyond the date of judgment, like here also in this case, is a different rate of interest. My learned will agree. So I'll leave it to your Lordship, but it's generally, Lordship, 7.5% is the most commonly applied interest, Lordship. It's a matter of fact, Lordship. I'm not trying to take any advantage from me. It's always a matter of discussion. In MSCT, what interest is to be applied has been left to the discussion with tribunal. There's an opinion varies from there in all cases. So this is my submission. I leave that income part, Lordship, without any evidence. It may be marginally more, Lordship, but not because there's absolute lack of evidence. We do not even know whether he was earning a profit from the business.
One more thing, you have submitted that the have already satisfied the award by in the 2018 itself. That was amount was accepted or they already it was there.
They have already accepted the amount. It was deposited before a tribunal in 2018.
2018.
So whatever he'll get is something only over and above that, if there is something to be paid. But I'll again at the cost of repetition, Lordship, I'll say that if it was earning a profit, they could have very easily established it by showing the passbook, or even that they were capable of repayments. Their capacity to repayment will depend on the business, how well he runs the vehicle. That would have been reflected in his passbook. That is not there. And repayment to the bank is also not there. Lordship.
And though
Interest
he
should be, as I'll agree to that part, interest should be in this case when we have taken 286 days to file the written statement, under 6 months to cross-examine. So it is a justified case of getting interest from the date of filing of the claim petition. And as regards the rate of interest, Lordship, I'll not make a lengthy argument. Even I have a huge bunch of judgments on interest. It will vary from decision to decision, Lordship. But 7.5, I think, is a very good reasonable rate of interest. It's one has to see lots of the rationale given that Kausnuma Begum's judgment, prevailing rate of interest in fixed deposits of nationalized banks. That I think is because at the moment, Lordship, I'm a super senior. Even I'll not get 9% anywhere. It's at 7.5% is, I think, almost all banks offer. Maximum. Maybe one or two banks might offer 8%. But no bank, there's no EA giving more than that. It has been like that for a very long time. For a very long time, the interest rate has been around 6%, 7% within that. Prior to that, Lordship, it used to be even 16%. We used to have instruments, this NSCs, National Savings Certificates, where it used to double in 6 years. But those now it takes 16 years to double that. So things change as per the state of economy. His judgments also say it depends on the state of economy and what is the prevailing rate of interest. Now it's around 6 to 7%. Maybe 0.5% can be given to make it 7.5%. But I think even that is very reasonable. That's my assumption, Lord. They are not. I don't know.
Not if only one submission, Lord, that common course of human event, a truck owner will earn an amount when he is maintaining a family. In a maintenance case, suppose we go, Lord, wife comes, Lord, that the husband is maintaining a truck, will naturally give them 14,000-15,000. That means the earning of the husband will go more than 30,000, Lord. He was having a driver on that time, Lord. That does not mean that no suggestion was also given, Lord, in the cross-examination part, Lord. If you have seen the cross-examination part, that he was a permanent driver, or if that suggestion would have come, you could have examined him, Lord, as a witness, Lord. That part of the evidence that I was driving my truck, I am the owner driver of the truck, has not been disputed. I have taken a policy of insurance, Lord, which covers PA cover for owner driver. I paid 100 rupees extra to the insurance company for that money, Lord, because I drive my truck. So all these factors, Lord, I have the permit to drive, Lord. The permit, the fitness certificate, everything is there. Why I will?
On the day of incident, most probably you were not driving.
On the day of the, I was sitting, Lord, with him, Lord. That was there. So on that day, Lord, but my averment in the evidence on affidavit that I am the owner driver and I used to drive my vehicle, Lord, has not been disputed in cross-examination. Had they would have disputed this part, Lord, now what my learned friend is suggesting, Lord, then I could have brought that witness, Lord, that I myself drive my truck, Lord. But at this point of time, Lord, it would be almost impossible to prove my case, Lord, if that argument of my learned friend is accepted. Well,
income was very clearly disputed.
Huh?
In the
In
cross-examination, income was very
30,000.
clearly.
The law is settled, my lord. That once I prove my mode of income, my lord, the presumptive calculation will go. Passbook thing also, my learned friend was introduced in the appeal, my lord. There was no suggestion in the that they have not brought this evidence or that evidence, Lord, in the cross-examination part. So at this stage, if Lordship asks us to bring this evidence, Lord, we will be prejudiced, Lord. Or my learned friend asks us to bring this evidence.
I'll never make a suggestion to my other side. How to
At
prove his
30,000
documents.
Milord per a truck driver, Milord, or owner, Milord. That is the minimum income that we can calculate, Milord.
He has to prove his documents. I cannot.
That's it. I am of that. This short written argument, Milord, on the facts only, Milord. Will furnish public. The copy detail. So on fact, this is how we can thank you. No, it is.
Matter is there.
Lordship,
Okay.
another
Can you tell us the
analogous matter.
number?
Number MSC appeal number 438/2019.
MSC appeal number
38
Yes.
2019.
2019.
Let the two matters may be taken up together immediately after vacation.
Muzumdar is also there.
Yes, Lordship, I'm responding there.
72 Lekki. Heard Mr. M. Kalpana and for the appellant. Considering this submission made by Mr. Let the present appeal be listed along with MSC appeal number 438 of 2019 immediately after vacation. Okay, it will be listed along with MSC 438 of
Immediately after vacation.
immediately after vacation.
No. Lordship, item 21 is, a date may be fixed after vacation. Lord.
21.
I got no
You
comment.
want the date there?
Lord.
I am the appellant there, Lord.
You are the appellant.
Yes, Lord.
Fixed date here. 23rd of October. 23rd of October.
In the month of November, first week. Lord.
January,
November. 6th of November.
Hello.
Item 18 and 22.
Would have had a request made by students of 6th.
Sir, item 22, both of us are
Item 22.
after vacation.
Kindly may fix a date, Lord. Or allowed.
The request made by immediately after vacation on. You want a fixed date here?
Lord.
30.
Oblige your.
Item 18 also, so I'm there.
Item 18.
18. Any difference after vacation?
Here the other side is available.
Other side, not
Item number 18.
18. So any
Nine,
date
eight,
convenient
nine.
ka korlo, sir.
Item number 18. no, pehle karne. No, other side 9.
My lord.
18.
Item number
Any date-
18.
Other side is not having any date.
Other side 9.
My lord,
Mr.
item number.
Mustafa, yes, they are not available.
Yes, no, sir, any date.
So that's what just we also inform us
Yes, that's
from
fine.
there,
They're
and
not-
who will inform you. But I have made a request that after vacation any date.
Yes.
I'm giving a star mark here. Okay.
My lord, item number 19, it is at the nick of the time, it is not taken by 3/4 times, my lord. So it may be fixed after vacation. Both the parties are present.
It may be taken on October, let's say, 23.
Yes, no problem.
23rd of October.
Yes.
That can, yes. Both parties are released.
Okay.
23rd of October.
Must have
We're
liked
listing it on 23rd of October.
23rd of.
My lord, item 24, my lord.
Item
24, supplementary list, hearing item, my lord. Early hearing order is also there. My lord, can it be accommodated on 30th of October, 30 October? That will be hearing day. All ailing person is 30.
You are for the respondent?
I will communicate it to my friend Meenmay Sharma.
You are for the appellant?
Appellant. Right now I will be communicating him. 30th October. Deeply obliged.
Okay.
Yes, item number 11.
11 was there. Yes, what is it?
Maybe taken about Thursday. Coming Thursday.
So it is in the hearing column.
Hearing column.
Thursday, I cannot say Thursday what will happen.
Actually, senior is
Because
coming.
Thursday we have already listed many matters on 18th. Some criminal matters are also being listed. So
Senior is coming from Delhi, so
Thursday he is coming.
no, he is available on today also, but he'll left Guwahati by 26th. Of
26th of this month.
Yes.
So you are for the appellant?
Appellant.
এটা হয়ে যাবে। Thursday না? You have made the other side.
No, I don't communicate.
No,
If he is available or.
then let's do one thing. At two, I have some criminal methods. So at two, in presence of the other side, we'll fix a date. You remain present. Your senior may not be there. Or if he is not there, then it's okay. Then we may fix it on Thursday, but let me ask the other side also in fixing up in Thursday, because the last week may be some problem. So we may hear the matter on Thursday, but just the consent of the other side. At two, we'll fix it.
Obliged.
আরো একটা matter, দুটো আপনার করবে। Just he.
11, item
asked-
11. This may be taken.
So, since suggesting that it can be taken up on Thursday.
Thursday,
will
I
be
am here.
convenient.
I am here. It may be taken
So
on
in
Thursday.
Thursday, most probably you are here.
Yes, yes.
You will be here.
All right.
So who is the other side?
All right.
Other side, my lord, MK Majumdar, Mr. MK
So
Majumdar.
we were waiting for the other side only.
My lord, since my lord 2015, my lord, they are not appearing subsequently after their name showing in the call this matter. They
They're
are not
not appearing.
No, my lord. Not even 2 or 3 days, my lord, they appeared. After that, my lord, they are not appearing.
Okay, yes. That time she made a submission and thought that let the respondent be come. That's why
The respondent may not come, your lordship. Now, if the respondent doesn't come for my lord, many days, my lord, they did not appear for the many days past. If that even, my lord, case may proceed, my lord, ex parte against them, your lordship, what is the harm, my lord? Because I am coming, my lord, I have come 2 or 3 occasions, but the case was not heard. And it is difficult for me, my lord, I am 76. Now,
It seems that they are not appearing.
Yes, my lord.
in between, the court has also passed some orders we have complied with. 2 affidavits are there, they are not coming up.
On 24/9/2022, Mr. PJ Sharma was appearing. But thereafter, most probably, no one had appeared. Heard Mr. Andhar. Heard Mr. Andhar, he done a counsel for the appellant. Done appears on call for this one. List matter accordingly on Thursday, the third on 18/9/2020. Okay, we'll try to hear the matter on 18.
Obliged, yeah.
Obliged.
নাহিলে একটু WhatsApp. Yes, Korea.
Yes.
Yesterday,
The informant side also had filed one objection.
CD received, my lord. CD is up to, my lord, 16/8/25.
yes. Milord will kindly come to the FIR, Milord. At page 18. With due respect, I would like to inform you
that I am the president governing body of Uttar Borpeta College, Dhanbandha, and the accused person is suspended principal of Uttar Borpeta College, Dhanbandha district, Borpeta. Last 28/1/25, the director of higher education department suspended the accused person. Actually, he was, I think what is sought to be conveyed is that as per the suspension order which was issued by the director, he is involved in misappropriation of 2 crores of money. I think possibly
Yes.
that is what he wants to say. And various financial scams and various financial irregularities committed by him. After issue of a suspension order, the accused person immediately filed a writ petition in the Honorable Guwahati High Court by challenging the suspension order which was issued by DHC on 28/1/25. It is mentioned after suspension, the accused person should hand over all documents of the college to the current principal, but he has not submitted. Current principal has issued 3 notices to the accused person for submitting various documents of the college, which is kept in hand. Instead of notice that the proceeding book was filed by the accused person in his possession before the Honorable Guwahati High Court as follows. A GB meeting is shown on 10/12/23, which is actually held on 10/12/22, which is mentioned in the line 3 of the first page. The meeting was fraudulently manipulating the resolution and submitted in the Honorable Guwahati High Court, and mentioned date is 10/12/23, which is totally totally false. My signature and seal themselves have been written in the proceeding book of the said meeting, that is 10/12/23. Signature and seals are not mine. The accused person is completely forged my signature, date and seal. Tapan Chandra Nath was not a member of the governing body on 10/12/23. His signature is shown in number 4 of first page of the meeting of the governing body. On 10/12/23, accused has a scan and the sign and pasted. The mentioned resolution number 6 of the proceeding book was not adopted by GB meeting of the college on 10/12/23. Resolution is completely false and manipulated and false. The signature of the GB president of the then GB Abdul Samad Ahmed was seen on 39/19 by the accused, and after the meeting ended with fraud. The resolution number 6 was not in original proceeding book. The accused person has submitted false pasted document before the Honorable High Court for his own benefit. In addition, after suspension of the accused person, he filed a copy of the Honorable Guwahati High Court for utilization certificate of 25 lakh, which was submitted in DHC on 2/4/25 during his suspension period. But his included vouchers are shown doubtful because government audit is still pending. Accordingly, the accused person forged the original proceeding book, keeping in his hand, and submitted the forged document before the Honorable Guwahati High Court to mislead it. To be honest, I could not understand, my lord, what is sought to be conveyed. Anyway, my lord, the first thing first, the informant refers to one order dated 21/8/1/25 of the director, whereby the petitioner is suspended.
Yes.
My lord, as far as after I got the brief, my lord, as I could lay my hands to the papers, actually, my lord, 1 crore was sanctioned to the college for construction of building and all during the time when the petitioner was the principal and secretary of the GB. Now, my lord, there was an issue of non-submission of utilization certificate. There is no allegation of any misappropriation, my lord. These are all over-enthusiastic persons, my lord, just poking their ugly nose. Now, my lord, there is no allegation. Nobody has sanctioned 2 crores of rupees for the college. What was sanctioned is, my lord, 1 crore of rupees. Regarding the last tranche, there was no utilization certificate.
Yes, 25.
Now, if your lordships, and regarding the other allegations, my lord, these are all, my lord, based on surmises and conjecture of the informant, my lord. If your lordship would kindly come to page 25, that will clarify everything, my lord. The charge memo in the disciplinary proceeding which has been issued to the petitioner. Now, how these figures have been, my lord, interpolated and, my lord, extrapolated in the FIR, kindly see. In exercise of the power conferred by the Assam Services Discipline Appeal Rule, the undersigned hereby ask you to show cause under Rule 9 as to why penalties prescribed in so-and-so should not be inflicted upon you for the following charges. Charge number 1. On scrutiny of the record, it was observed that 1 crore was sanctioned for infrastructure development of Uttar Borpeta College for the year 17-18 by Director of Higher Education. The plan estimate of rupees 1 crore was prepared by Assistant Executive Engineer Borpeta, Building Subdivision. The technical sanction for the work was accorded by Superintending Engineer so-and-so, dated 19/12/17. As such, you have submitted utilization of first installment of 50 lakh, but the final completion report duly signed by the technical person for construction committee is not produced. So there is no allegation of 2 crore and misappropriation by the petitioner, my lord. On the contrary, the allegation is that 50 utilization certificate to the extent of 50 lakhs was to be submitted. That is also there, I'll show, my lord. Unauthorized absence from duty of Saifur Rahman, tutor assistant professor of Uttar Borpeta College. Based on the documents furnished by you, it was observed that Saifur Rahman, tutor assistant professor of Uttar Borpeta College, was absent on multiple days. The matter was initiated to the Director of Higher Education by you regarding unauthorized absence of Saifur Rahman, but it is not clear how the remuneration of Saifur Rahman was paid during the unauthorized leave period. What had happened, my lord? The gentleman Saifur Rahman was persistently, my lord, absentee. So I wrote to the director how to deal with it. Then director advised me that treat it as a leave of the kind due. That is how I have done it. If leave of the kind due is to be given, then he'll get a salary. Then, my lord, there is a particular fishery which is the college managers. In respect of that, some allegation is there. But is not a part of the allegation in the FIR, my lord. The college authority has listed out a fishery to various parties as per letter mentioned below. So these are but you have provided money receipt of the following amount. So, my lord, this is the basic charge against the petitioner. So, my lord, this mention of 2 crores of rupees misappropriation, these are all based on wild imagination of the, my lord, informant. Now, end of the day, my lord, I am a principal. I am under suspension. Now, my lord, where do I go? How do I interfere with the, my lord, day-to-day activities of the college or even to investigation, my lord? Now, the entire allegation has been, my lord, distorted. In fact, my lord, regarding the remaining 25% of the utilization certificate, that also we have provided, my lord.
29.
Yes. If your lordship would kindly come to page number 29. Kindly see, my lord. At page 28, my lord, I forwarded it to the director. With reference to the subject cited above, I have the honor to submit herewith the utilization of 20 lakh sanction for infrastructure development of Uttar Borpeta College, by later mentioned above, for the year 22-23, which is utilized fully as per plan and estimate, and final completion certificate is enclosed with voucher number 01292. Now, this is the, my lord, the audited certificate, utilization certificate given by chartered accountant, and one is at page 29 and other is at page 30.
Complete certificate.
And please come to page number 36, my lord. Now, the completion certificate given by the concerned, my lord, Executive Engineer of Public Works Department. This is to certify that infrastructure development of Uttar Borpeta College, Anabandha, and first floor, ground floor of a RCC building interlocking concrete block pavement, college gate with part boundary, sanitation facilities, installation of electric equipment, supply of library books, phase 1 and construction of G+1 RCC administrative building have been completed as per estimated amount of rupees 1 crore as per installment basis, white dated so and so as per the technical section obtained from the competent authority. Well, the basic allegation is I have misappropriated 2 crore. Where from this figure 2 crore has come below? Sanction was for 1 crore and money has been utilized. Well, in the small places, well, there are a lot of issues, my lord. It's very difficult to comprehend. Anyway, my lord, here in this case, I am a principal of the college. Where do I go, my lord? I have my roots in the society. I'll cooperate with the investigation. And my lord, this regarding this date, it is a fact, my lord. The resolution was written on, my lord, that particular date. I'm having that copy, my lord. I have a photocopy. Let them find out from the original, my lord, what is what.
Suspended.
Kindly see, my lord, this is the one. If your lordship will kindly see on the left-hand side top, my lord, approve. That is the signature of the president, 10/12/23. And it is a fact that meeting was held on, my lord. If your lordship will kindly come to towards the bottom, a meeting of the GB of Uttar Pradesh held on 10/12/22 at 10 a.m. in the college premises under the presidency of Zahir Ali Khan. In view of the notices, the president took chair, etc., etc. So various resolution amongst others were taken.
All record,
And my lord, these are all records from the college. Let the IO, my lord, lay his hand to it and find out what is what. And my lord, whatever, and in fact, it is I who has brought this document on record in the writ petition, my lord. My lord, I think, my lord, there is nothing, an issue which is, nothing has been blown out of proportion, my lord. Therefore, I'll humbly submit, my lord. It's a case where perhaps lordships would like to.
Allegation is also there that in that meeting only,
Yes,
we have forged the signature of.
that is the allegation, my lord. So they can lay the hand to the original records and they can take the investigation to the logical end, my lord. But for that, why my custodial interrogation is necessary, my lord? Well, this is document which I myself is volunteering. Because I was the principal of the college, I know. Now the originals are with the present incumbents. And my lord, when I was on interim bail, I have provided everything, my lord. In fact, for 2 months I was on interim before rejection of the bail. And therefore, my lord, during that period, I have fully cooperated. I have provided all the documents. And the protection given by the Supreme Court in Anes Kumar, my lord. If your lordship would kindly come to page 39, which I have annexed, my lord, just one paragraph. My lord, the Honorable Supreme Court dealt with the aspect why in such cases, page 39, my lord.
Anish Kumar.
Yes,
Yes, that, my lord, somewhere in the middle. From a plain reading of the aforesaid provision, it is evident that a person accused of offence punishable with imprisonment for a term which may be less than 7 years or which may be extended to 7 years or with fine cannot be arrested by the police officer only on his satisfaction that such person had committed the offence punishable as aforesaid. Police officer before arrest in such cases has to further be satisfied that such arrest is necessary to prevent such person from committing any further offence or for proper investigation of the case or to prevent the accused from causing evidence of the offence to disappear or tampering with such evidence in any manner or to prevent such person from making any inducement, threat or promise to witness so as to dissuade him from disclosing such facts to the court or police officer, or unless such accused person is arrested, his presence in the court wherever necessary cannot be ensured. These are the conclusions which one may reach based on facts. Law mandates police officers to state the facts and record the reasons in writing, which led him to come to the conclusion covered by any of the provisions as aforesaid while making such arrest. Law further requires police officer to record reasons in writing for not making the arrest. In pith and core, the police officer before arrest must put a question to himself. Why arrest? Is it really required? What purpose will it serve? What object will it achieve? It is only after these questions are addressed and one or other conditions as enumerated above is satisfied, power of arrest needs to be exercised. In fine, before arrest, first the police officers should have reasons to believe on the basis of the information and material that accused has committed the offense. Apart from this, the police officer has to be satisfied further that arrest is necessary for one or more of the purposes envisaged by the subclause. So therefore, my humble submission is, my lord, in such cases where the 7 years and less, my lord, it's not imperative that in each and every case arrest is a must which must be exercised. So, my lord, having regard to the facts of the case, where the allegation is of non-submission of utilization certificate which was eventually done, and my lord, because some salary was paid to a teacher who was on leave, that too based on the order of the director, and regarding the fishery revenue also we have explained, my lord. I don't think, my lord, it's a case where my custodial interrogation is a imperative, my lord. In that view of the matter, I will respectfully pray, my lord. Since I was earlier enjoying the benefit of the ad interim pre-arrest bail, Lordship will extend the privilege of pre-arrest bail to the petitioner.
Yes.
Your Lordship, I would like to first point out, my lord, regarding, but this is not the first anticipatory bail application. It is subsequent. Exactly. Subsequent, my lord. Now, my lord, your Lordship may kindly come to page 47 of earlier rejection order. Thereafter, I will point out one by one from the CD, my lord. Mr. Sharma, the learned additional public prosecutor submitted in this regard that there are sufficient incriminating material against the present accused petitioner, and as per allegation, he has misappropriated around 2 crores of money, that is allegation, my lord, which was sanctioned, and by creating some false resolution showing to be held on 10/12/23, he forged the signature of the in-charge principal as well as one Dr. Tapan Chandra Nath. That the statement of Dr. Tapan Chandra Nath is available in the case diary, my lord, who were not even the member of the governing body, and forging their signature, one resolution was made fraudulently. He further submitted that from the materials available in the case diary, it is seen that in spite of the objection raised by Dr. Nath, he produced some false resolution before him, stating that the objection of misappropriation 1 crore 90 lakhs has already been resolved in the general body meeting. Regarding that aspect also, my lord, thus he has misappropriated huge amount of money and cheated the department, and also committed the offense of forgery by forging the signatures of some of the members of the governing body. So, my lord, on that basis, and that is not only the submission, regarding that, my lord, there are materials in the case diary, my lord. Now, your lordship may kindly come to, my lord, the order of the suspension, my lord. Page 22, my lord. This is not that only after inquiry, my lord, preliminary inquiry report. Page 22, my lord. Whereas an inquiry committee was constituted by letter so and so to inquire into the matter of financial irregularities alleged to be committed by Mr. Zahir Ali, the present principal so and so. As per the preliminary inquiry report received on 23/11/24 from the inquiry committee comprising of Gayatri so and so, financial irregularities have been committed by the principal. So on the basis of the preliminary inquiry report, the suspension order has been issued, my lord, against the petitioner. Now regarding, my lord, the present petitioner, the petitioner, page 4 of the petition, my lord, this is not only the first case of misappropriation money, that is in the petition itself, my lord, mentioned that, my lord, the petitioner was earlier, paragraph, page 4, my lord, paragraph 4 of the petition.
Page?
Page 4 of the petition, my lord, petition itself, my lord, paragraph 4, my lord. Third line, my lord. The petitioner was earlier arraigned in Borpeta PS case number 1085, 2022, arrested, suspended on remand. So this is not the first case that he is, and regarding that case, my lord, as per my knowledge, that is regarding misappropriation of some scholarship fund of the students. So, my lord, here, after obtaining the interim order, my lord, here petitioner initially granted interim on 18/6/25. Thereafter, he appeared before the IO on 25/6/25, my lord. Regarding those original documents, my lord, which he has not submitted, my lord, what he has stated, your lordship, I would like to point out, my lord. After obtaining interim protection from this honorable court, my lord, although those documents were made a part of the annexer of the writ petition, my lord. May I read, my lord? My name, মোৰ নাম আৰু ঠিকনাৰ ওপৰত লিখা মতে সত্য। মই 1995 চনত উত্তৰ বৰপেটা কলেজ ধনবান্ধাত লেকচাৰাৰ হিচাপে যোগদান কৰিছিলোঁ। তেতিয়া উত্তৰ বৰপেটা কলেজ ধনবান্ধা ভেঞ্চাৰ আছিলে। 2013 চনত খন প্ৰাদেশিকৰণ হোৱাটো। So I will only point out the relevant portion, my lord, regarding the submission of document. Only the relevant portion, my lord. যোৱা ইংৰাজী 28 তাৰিখত 2025 28/1/2025 ডাইৰেক্টৰ অফ হায়াৰ এডুকেশ্যন ডিপাৰ্টমেণ্টে উত্তৰ বৰপেটা কলেজ ধানবান্ধাৰ গভৰ্ণমেণ্ট ফাণ্ডৰ প্ৰায় 2 কৰোৰ টকা আত্মসাৎ কৰাৰ অভিযোগত মোক ছাছপেণ্ড কৰিছিল। তেতিয়া মই গুৱাহাটী হাই কোৰ্টত ৰিট পিটিশ্যন সহ কিছু নথিপত্ৰ দাখিল কৰিছিলোঁ। দিছ ইজ ইম্পৰ্টেণ্ট, মাই লৰ্ড, যিখিনি মোৰ ওচৰত ফটোকপি আছিল। So on the basis of the photocopy of those documents, my lord, he filed a writ petition before this honorable court, and on the basis of those photocopies of the, my lord, original document, those were certified by the, those were also, my lord, certified that this is a true copy, certified to be true copy of the original, my lord. So only on the basis of that photocopy, my lord. Original, যিখিনিৰ কোনো ধৰণৰ অৰিজিনেল কপি মোৰ ওচৰত নাই, সেইখিনি মই আগতে উত্তৰ বৰপেটা কলেজ ধানবন্ধাৰ বৰ্তমানৰ প্ৰিন্সিপাল আবুল হুছেইনক সমজাই দিয়া হৈছে। So, my lord, as per his statement that, my lord, he has submitted, but till now, regarding governing body resolution, recent resolution, also that he has not submitted, my lord. Though, suppose, my lord, he has with him only the photocopy, my lord. How only on the basis of, my lord, photocopy of those documents which were in fact submitted by the council appearing on behalf of him in the writ petition, my lord. So, my lord, that needs to be, my lord, countersigned, verified, my lord, certified to be true copy. So only on the basis of those, my lord, photocopies, writ petition filed by him before this honorable high court, my lord. And now allegation is that he, by forging the signature of the, my lord, some of the members of the governing body, by forging the seal and signature of the governing body, he has, my lord, filed this writ petition before this honorable court. And regarding that, my lord, the members who were present at that point of time in the governing body, his statement is available. My lord, governing body's precedence, my lord, letter is also available there, my lord, written to the director of higher education, how he has, my lord, without his, my lord, that letter is also available. My lord, that in the rejoinder affidavit also, my lord, he has submitted those copy of the, my lord, governing body resolution by forging the signature of the, in fact, those person, one, my lord, Tapan Chandra Nath was also not present, and the earlier governing body president, my lord, Abbas Samed Ahmed also, my lord, his letter is also written to the, my lord, director of higher education regarding all these, my lord, forgery. This is also at the time of filing. That letter is also available in the case there. So considering all these aspects, my lord, this person is not only involved in this particular my lord, case for my lord, misappropriation of public fund, government fund, my lord. Earlier also, this accused person is involved in committing such type of offense, my lord, misappropriating, my lord, scholarship funds, my lord. In that regard, paragraph petition of the paragraph 4 is itself, my lord, petitioner, my lord, that case number is also, my lord, mentioned. So considering all these aspects, my prayer before lordship, these are public money, my lord. Being a principal, he is involved in committing this type of offenses, and that too, my lord, utilization certificate hurriedly, my lord, after suspending him, my lord, he has submitted only utilization certificate is not sufficient. How you have utilized? And here in this case, my lord, petition, my lord, he has submitted a utilization certificate, my lord, signed by the CA, my lord. Your utilization certificate, how you have expend those money of the, my lord, state, my lord, you will have to submit those vouchers and everything only because a document prepared by the, my lord, CA. How you can submit that document, my lord? Because you have utilized that money. Now you will have to answer, not only because by showing on certain figures that in that way you have, my lord, expend those, you will have to submit all those details.
But considering the statement of the petitioner,
Yes, ma'am.
as to what work has been done or whether there is any completion of work, on that basis only after verification, the work order work, completed by the accused petitioner, then only the completion certificate was issued was approved.
Yes,
On the
ma'am.
basis of those documents or those verification, there will be a duty cast on the
My lord, that
person also
yes.
while issuing the completion certificate.
Those documents audit has to, my lord, verify, audit has to submit report. Regarding that, my lord, the government audit has to, my lord, submit report regarding the genuineness of those, my lord. This is not CA, my lord. Though private CA cannot, my lord, verify the
Who issued
genuine.
the completion certificate?
Regarding those, my lord, I am just pointing out that he has submitted a utilization certificate. That I have utilized this amount of rupees 25 lakhs. Only utilization certificate is not sufficient. While utilizing that money, those, my lord, how you have, my lord, utilized those money, you will have to produce all these vouchers. Thereafter, government audit has to verify the genuineness of all these documents, my lord. And my lord, most vital, my lord, the vital point is that, my lord, by, my lord, on the basis of those photocopy of those governing body results on those documents, he has submitted writ petition, file petition before the honorable court. So, my lord, this is not a fit case, my lord, for granting anticipatory bail to the present petition. This is my submission.
Well, I'll just take 5 minutes time, Miller. My learned friend refers to para 4, page 4 of the petition to say that I was earlier involved in another criminal case. Milord, this is a case where, Milord, the CGM granted me bail because in the meantime, Milord, UGC has clarified, Milord, that for the Dokhin, this college in question, no money was sanctioned by the UGC for scholarship. Milord, as I submitted, Milord, these are rivalry between the different groups, Milord. Milord, this scholarship money was never sanctioned in the name of Milord or college in question. Therefore, there was no occasion for him to misappropriate because no money has come from UGC. That was clarified in the earlier proceeding. Now, my lord, my learned friend refers to page 22, that is the suspension order. I think my learned friend knows it, my lord. When can a person be placed under suspension? Either a proceeding is pending or a proceeding is contemplated. Now, my lord, page 29 is the, sorry, sir, sit for the Page 25 is the charge sheet, my lord. Charge memo in the disciplinary proceeding. It does not speak of 2 crore, my lord. It speaks of only 1 crore. That too, my lord, non-submission of, my lord, utilization certificate. And the second charge was regarding Saifur Rahman's salary, because the director himself said, treat his application as leave of the kind due. And fishery revenue, that part is also settled. Now, where are the other allegations? Well, in a general way, can you conduct a criminal investigation, my lord? It must be pinpointed. Because end of the day, you will be tinkering with the liberty of a subject. That's why, my lord, in Anes Kumar, Supreme Court has said, in such cases, whether it is really necessary. My lord, my learned friend being emotional and making a submission will not do. End of the day, what is the material before you? The material must be in the case that what material is there, my lord? that I have not submitted the utilization certificate. Your allegation is non-submission of utilization certificate. Your allegation is not of misappropriation. Let us be very clear about it. And my lord, this utilization certificate is of 2021. And what you were doing? Please come to page 29. And he was not the president. And my lord, this Mr. Nath, yes, in 2022, he was a member of the executive, the governing body. It is only when, my lord, the resolution was signed, that was in 2023. Kindly see page 30, my lord. It is 22. Then, my lord, at page number 31, these are all 22. 21, what we are doing all for over all these years? This 50 lakhs utilization certificate is given. So, my lord, the director had information regarding non-submission of utilization certificate, and that aspect, my lord, for which a DP has been instituted. My suspension cannot be correlated with the reasons shown by my learned friend, because suspension, in continuation of the suspension, my lord, the show cause notice was issued. Show cause notice does not contain all these allegations. So therefore, I think, my lord, everybody is proceeding on some, my lord, hyper-technical basis. That is not how a criminal law operates, my lord. It has to be, one must be in a very definite situation. Everyone should know, this is the allegation against me, this is what I am to meet. And my lord, director has never raised any such question, my lord. Otherwise, the show cause notice would have also revealed that you are guilty of misappropriating government money. That is not there. So I think, there is some communication gap somewhere, my lord. And this president, my lord, he must be having some grudge against the petitioner. That's why he's personally taking things, my lord. So therefore, my humble submission is, my lord, it's not that I have abused the authority or something, my lord. I'll continue to cooperate. Therefore, I'll respectfully pray, my lord, my case for grant of bail may kindly be considered.
Well, I'm handing over the case there. I have flag marked the statement of those and governing.
Yes.
Yes, fourth. Deeply obliged.
Yes, Lordship, I am for the informant, Lordship, and for the an in-charge principal of the broadcast.
Yes. Submit on the resolution which is produced before this court. This is a resolution, seems to be, the meeting held to be on 10/12/2023.
On and Lordship, already the departmental proceedings was going on. And
yes, that is there.
On the yesterday, Lordship, he was removed from service.
Already.
Chief, this is the.
This is new development.
Lordship, his bail may be rejected. And Lordship, one more thing, Lordship. Some important documents is still in his hand, Lordship, and he has not returned the same. Lordship, and GB resolution has been taken, and GB, present in-charge principal sent notice on several times, but no fruitful result has come out. So his bail may be rejected.
So this is the latest development that he already got terminated.
This is the letter that he has removed from service. Yes, that is.
Lord. May I please, Lord. Question. In respect of submission of my senior, only purpose of this letter, Lord, can I say something about? Lord, this is helpful for us only, Lord. Kindly see, there are so many allegations. Only two allegations is here, Lord. 1 and 2. Kindly see. Number 1, which allegation are proved? Only 2 allegations proved. They have saying in the FIR so many things, 2 crore, forgery, everything. But here prove only 2 things. The sanction infrastructure development amount is still not fully utilized. Construction work remain incomplete.
the utilization certificate submitted by Dr. Zahir Ali, principal, under suspension Uttar Barpeta College is not as per norms. Not as per norms. What is the norms? They have not said, and nothing in the case there also, I think, about the UC. So only UC is not submitted as per norms. This is the first allegation proof, and second allegation not proof. Total 3 allegation. If Lordship come to the allegation in charge memo, only 3 allegation is there. Only 2 allegation proof, and second is fishery. We have leased fishery. So some amount they have given, we have submitted the all receive, money receive everything. Some amount and they have not given because the overflood, the all things they have filed some petition for condone the everything, condone all all the fishery fees, everything. So some amount we have already paid and some amount already condoned. So these are the allegations, only 2 allegation proof. So they refer in the FIR, refer the suspension letter. Kindly see the FIR, Lordship. In the they refer on the basis of suspension only. Their FIR is on the basis of suspension, and in the after suspension the DP is completed. And what is come in the DP? Only 2 allegation is proved, which are not part of the FIR. So what is the right of the complainant to file this FIR? Where is the documents? Where is the everything that 2 crore is misappropriated? All are false, false, Lord. In fact, I will give this letter this one part of this. Listen here. So everything is clear from this, Lordship. Although removal, whether legal or illegal, we will challenge or whatever, Lordship. But this order, speaking order, removal order, everything is clear. What are the allegations against me? And on the basis of charge only, they have inquired the matter and only 2 allegations proved. So FIR now the part of the all the allegation in part of the FIR all are false. It will prove from this letter only. Because in a suspension and after suspension, the inquiry committee submitted the report. The inquiry committee findings is there. On the basis of inquiry committee findings, I have removed from the service, which may be legal, which may be illegal. This is a different part. This is not portion of the part of the FIR, Lordship. FIR is completely different. Their FIR is beyond the jurisdiction of the suspension, everything, Lordship. Completely false concocted. That's my submission.
Lordship, College Authority has facing some problem due to lack of documents. Lordship.
Who?
College Authority, Lordship.
College Authority.
College Authority. Some important
But the-
documents still in his hand, Lordship. So,
But that's why I just asking. Earlier he was on interim protection, but subsequently that has been cancelled by the last order.
Lordship.
But while he was on interim protection, there was a direction to cooperate with the investigation. That has not been done. Or what do you want to say?
that has not been done, but he has not communicated with the GB president or college authority. So a notice has been sent to him.
But so far I can remember there was a statement earlier that the documents, all the documents has already been handed over and the signatures were also obtained accordingly.
Yes.
In the last order I have mentioned, I think.
Lordship.
But the question is that apart there may be some documents, but during the interrogation or at the time of when he was enjoying the
not
the interim protection, at that time there was no
submitted.
no what police was doing then. He was before the authority. Now have you this your in your objection have you filed all these things regarding that
resolution?
No, resolution is okay. What kind of document are still you are want? These documents, how it is? List in there? Where?
Yes, the list is there.
Ah. And out of those listed documents, was there
There
any?
is no proof. I have not found anything that he has submitted all those documents. The logic may kindly give us only one thing, my lord. His statement, very vital, my lord, 125 kilometers, very good. In his statement here, he stated that he has only the photocopy of those documents, not the original. If suppose only photocopy, then my lord, state will have to again file a case against him, because how on the basis of photocopy will he annex those documents while filing the.
That's
And
why
then was there any procedure that while filing the writ petition?
I will have to first, my lord.
No, while filing the writ petition, whether the office did not.
Because, my lord, there is a provision that you have to, while filing, while annexing those documents, the council appearing on behalf of the file of petitioner has to certify those documents, certified to be true. So how can I, my lord, certify, countersign my signature by showing that it's certified to be true? Only after, my lord, verifying the original of the.
Obviously.
of that document. So, my lord, that original, if he is not with him, how he can approach the court by annexing all these documents? So, my lord, allegation that he forged the signature of all these, my lord, persons of the members of the community, his signature, I know the signature is true, my lord. If only on the basis of the photocopy, he has filed this verification before this. You know, if I kindly tell us in that, that some of the allegations is also there regarding file of the file.
Lordship, may I point one thing? Their allegation is this: we have already in the earlier case also, in the present case also, we have made the statement that I have only Xerox copy because after my suspension, I leave all the documents to the college authority. College authority saying some documents is not given, he saying some documents is given. So this is the dispute. That's why the FIR was filed that these documents was forged. So that part will come after only the trial proceeding, whether he have forced, whether there is any original copy with the college authority or with him. That part will come in the trial proceeding. So in present stage, how they can say this is forced, how they can say this is not a resolution of 2022, 2023. That's why they have filed this FIR. My learned friend saying that it may be another case. This is the case, Lordship. Forgery case, this is the forgery case. They.
Now he admitted that he is having on the Xerox. So only Xerox copy will be. Why he has annexed all those documents while planning it without annexing those documents can make statements. If only the
That I'm not in a position to support.
with him, why he has filed all these documents along with the writ petition? That means you have filed all.
Who was the council who filed the writ petition?
I am the
So
counsel and my senior.
you had filed the writ petition
Yes,
without producing the original.
my senior is
Considered to
also
be
here.
the certified copy.
He
You certified it is to be true without producing the original.
said that original is there.
There could have been a statement, as Mr.
No,
Whatever has submitted.
yes, Lordship,
But
but
obviously there could have been statement that we are not in a position to submit anything as all the originals are with the school authority. Or there may be made before the report itself.
Yes.
That those may be called for from the school authority, because I don't have, as I'm under suspension.
that
But
statement I
without,
have.
without doing this, you have certified all the documents without producing the original that you have now admitted also.
No, he said that original is there.
Ah.
I have never said that there is no original. But
No.
original
At
is
the time of certifying those copies,
yeah.
without producing the original, you have certified to be true. That's what he is pointing out. That means the original was not before the council also.
Yes.
Not before the council, as you have submitted that those originals were already in the school authority. Understood?
Yes.
It is within the custody of the school authority as you are suspended.
Yes.
So under suspension, when you are under suspension, you may not be in the position of those documents, admitted.
Yes.
But while filing the writ,
Yes.
you have filed the writ only on the basis of the photocopy.
Not read, Lordship, just one reply, Lordship. Reply
No,
affidavit.
no, read petition after
Yes, in
suspension.
writ petition, I have filed a reply affidavit of the government, not in the main writ petition. I have the.
No, we are not following. We are not on there.
Yes, yes, that,
He is saying that one writ petition, you have filed one writ petition. Admittedly, you have filed one writ
Yes,
petition
yes.
after your suspension.
yes, yes,
Isn't it? After suspension, you have filed one writ petition.
yes,
In the writ petition, obviously, there has to be some document annexed
yes,
by you.
yes,
And those were certified by the council,
yes,
certified to be true.
yes,
Now, Mr. Bhattakur is pointing out those documents we have certified to be true without perusing the original. That's what. There was no prayer made. Was there any prayer that we are not in a position of those documents? So prayer may be there from the to call for the original copy from the school authority. There was no there.
no,
The
my,
court was on belief that these certified copies are true copy.
no, my lord, may I point out, Lordship, my senior is the advocate at that case. My senior K.N. Sulri. What happened, Lordship, the main writ petition, I have all documents is there. In the main writ petition, we have not annexed. When they file an affidavit, government file an affidavit, we file a reply. In the reply affidavit, that documents we have given.
Originally, you have not filed.
No, we have not filed with the writ petition.
Acha.
We have filed, not filed. I have the writ petition copy also, Lordship.
But in the affidavit, Lordship, I think.
He,
The original, but photocopy, they may annex, but that needs to be certified with copy.
No, now he is saying that they have not annexed any document.
No, Lordship.
No,
They have annexed.
we have
They
annexed.
We
We
know
filed-
from the additional affidavit, they have filed.
not a additional, reply affidavit.
Reply affidavit, sorry.
There are lots of things. And by following those documents, that is the allegation in the FIR.
Lordship, from the reply affidavit, we know that on that day, on 23, that GB meeting was held on. From the reply affidavit, we know it.
In the
As a GB president.
in the writ petition order, Lordship,
They
everything.
have annexed
The writ
this.
petition order also mentioned, Lordship. After that, they have filed this FIR. In the writ petition order, all part are mentioned in the order of the dismissed and
No, just tell us that at the time of filing writ petition, have you annexed?
in the main
document?
writ petition, we have not annexed. We annexed with the reply affidavit. Reply affidavit filed by the government. Government file affidavit, we reply.
So during reply,
They have all.
That part come up in the writ petition, Lordship, and learned single bench while pass the ordering, every decision, everything is discussed. That's why they have filed this FIR on the basis of that affidavit.
Knowledge comes
So
from-
if
from the-
everything will come up after trial, Lordship, let's.
Yes.
It will writ petition order.
Okay. Oh, that's CD2 added. 18.
I will.
Number 83. Submit the pencil, you go ahead. R. Goswami, the learned counsel for the applicant. None appears on call for the respondent. Considering the submission made by Mr. Goswami, the estimate immediately after Puja vacation, as on a date to be filled by the page. Watakurba, where are you now at present in the bench of
Court number 24.
24 means Pranjal? Acha.
24, मतलब 9.
Pardon?
Court number 24 is something. Court number, my lord, 9 also, 18 also.
Oh. In the morning of that was here.
Yes.
And for this purpose only you were there because you have raised 18 nikite. Are you on 18?
No, ma'am.
No. Item number 18 you are appearing?
No, ma'am.
Acha. You have any matter?
No.
Okay. ঠিক আছে, okay.